Grand Yes.
Nothing made.
Huh?
And that was the minimum section.
Fresh matter, sir. Kodi. Fresh matter, sir. There Baradilla. Baradilla. Kodi. Huh? Yeah? All right.
Without compensation,
I three. If it is a fresh matter, I will hear. Otherwise, it will come in the due course. Yes.
Stating that I have inquired about the proposal.
What is it? Is it a fresh matter? Please give them. Kodi. Yes.
Old matter, I have been filed. The case very good.
I file ಮಾಡಿದ್ರೆ IML ಬರುತ್ತೆ ಬಿಡಿ. When did you file the IA, sir? ಅಲ್ಲ ಮತ್ತೆ ಇವತ್ತು ಫೈಲ್ ಮಾಡ್ಬಿಟ್ಟು ನಿಮ್ಗೆ ನಾಳೆನೇ ಬೇಕು ಅಂತಂದ್ರೆ ಏನ್ ಮಾಡೋದು? We'll see. Yes. Follow the matter. What are you asking in the representation?
I have made an application from the NRC cultivator. I am personally cultivating. And next year, I also paid.
Next year is a receipt.
Receipt. Next year, see, 57.
When did you file?
It is on 15/18.
2018.
18. So kindly see. In the next year, application date. Kadra ಏನು ಸಂಬಂಧ ಇದ್ದಂಗಿರಲಿ.
ಏನು what is annexure A?
Receipt ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು.
Receipt for what?
For payment of fees for the making application at the time of making.
ಇಲ್ಲ ಅದಲ್ಲ. ಅದಕ್ಕೆ ಏನು ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ.
ಅಲ್ಲ ಅದು ಫೀಸ್ ಇಲ್ಲ ಬಟ್ ಇದೇನು
ಗೊತ್ತಿಲ್ಲ. We do not know. Let them consider.
ಇದು annexure C
filed an application in the prescribed form in the year 2018. Let them consider it. So same order, Sama. To consider the application seeking regularization of unauthorized occupation. The Tahsildar is directed to place the application along with the report within a period of 2 months from the date of receipt of a copy of this order. The committee shall thereafter consider the application and pass necessary orders within a period of 2 months from the date when the application is placed by the Tahsildar before the committee. Learned AGA takes notice for all the respondents. Remodel.
On the basis of it, the result of disposition. The collection was lost. Yes,
all right. Same order, same interim orders as in WP number 19334 of 2021, dated 17th of January 2022. Learned ATA takes notice for all the respondents. ಬೇರೆ ಯಾರು ಇದ್ದಾರಾ? ಸ್ಟೇಟ್ ಬಿಟ್ಟು ಬೇರೆ ಯಾರು ಇದ್ದಾರಾ?
Thereafter, he sold in favor of one.
ಮುನಿವೀರಪ್ಪ.
Chikka. He in turn sold it in favor of Venkatram.
ಮುನಿವೀರಪ್ಪ ಅಂತಿದೆ.
Original grant. He sold in favor of Chikka.
ಚಿಕ್ಕ ಕೆಂಪಮ್ಮ.
3 acres. He was granted 4 acres.
1947.
Annexure B. I have produced EC. All the sale transactions have been reflected. From that date of purchase, we have been in possession and enjoyment. In the year 2014, it is said that our occupation is illegal, and now the Deputy Commissioner passes order on the ground.
One nimsha. 1976, Venkataramu purchased 3 acres.
Yes. Thereafter, he sold 2 acres in favor of
Muniyappa. Muniyappa is the petitioner. In the year 1979, when was his name entered in the land records?
From that date onwards, he has been in possession. All things stand in name.
Where is the mutation entry, sir?
Mutation entry, I have not.
ಮತ್ತೆ?
We have been in possession.
ಆಯ್ತು, ಏನಾಯ್ತು? ಅದಾದ್ಮೇಲೆ ಏನಾಯ್ತು ಈಗ?
Now, Annexure C is the notice, was a notice issued by the Deputy Commissioner on 17/3/2014, saying that your authorization, your cultivation and occupation is contrary. He exercised power under section 136(3) of Land Revenue Act, and for which we have our objections. Now, the Deputy Commissioner says that we did not produce grant certificate, therefore, order is passed for cancellation of entries and resumption of land to the government.
Is the order?
Extreme.
Page number 20. Page number 20. Okay. On perusal of second part, on perusal of the submissions made by the respondents and looking into the document, I am of the opinion that those respondents containing that the land in question has been granted in favor of Munivira in the year 1946, and he has not produced any grant documents in support of his claim. Hence, I pass the following.
Perfect.
Here also, in writ also, they have not produced anything. Or RTC, not MR.
Learned
Possession and enjoyment is not disputed.
takes notice for both the respondents. Learned counsel for the petitioner is directed to serve a copy of the petition on the learned ATA. Next para. Learned counsel for the petitioner submits that the petitioner herein purchased 2 acres of land in survey number
110/2.
110/2 of Tailagere village, Kundana Hobli, Devanalli Taluk, under a registered sale deed dated 24/2/1979. Stop. Initially, 4 acres of land in survey number 110 was granted in favor of Shri Munivirappa. Stop. Under a registered sale deed dated 6/10/1947, Shri Munivirappa sold 3 acres of land in favor of Srimati Chikka Kempamma. Stop. Srimati Chikka Kempamma sold 3 acres of land under a registered sale deed dated 21/10/1976 in favor of Venkataramu, the vendor of the petitioner herein. Stop. Then a council submits that the names of all the purchasers, including the original grantee, were entered in the land records. And long after the petitioner's name was entered in the land records, a notice came to be issued by the Deputy Commissioner
17/3/2014.
on 17/3/2014, purportedly invoking the revisional powers conferred under section 136(3) of the Karnataka Land Revenue Act, 1964, alleging that there was no grant made in favor of Sri Munivirappa. And therefore, the petitioner was called upon to answer why his name should not be deleted from the land records. Stop. Then a council submits that in spite of bringing all these aspects to the notice of the deputy commissioner, the deputy commissioner has proceeded to pass the impugned order dated 10th of June 2022, only on the ground that the petitioner has not produced any grant documents in support of his claim. Full stop. Next paragraph. There shall be an ad interim order of stay of the impugned order dated 10th of June 2022 at annexure A, till the next date of hearing. Next paragraph. Statement of objections shall be filed at the hands of the respondent state within a period of 2 weeks from today.
In this case, landing the room rated of room unauthorized. He filed application pursuant to his application. Land is granted and granted on 31/8/2005 itself. And thereafter on 8/10 to 11/8/2010, the Tahsildar, after getting survey of the land, prepared the list of granted. They produced the thing annexure C, I think page 17. My name is serial number 25.
Page number?
Page number 17. Serial number 25 is at 18, page 18. Rodana bin Maraf. I have similarly placed person have been issued Savole checks, but I have not been issued. So I prefer a writ petition 86/28/2022. That order is at annexure
F.
Annexure F. Page 54.
Yes.
The honorable court was pleased to direct the respondent to consider our application within a period of 2 months, 3 months. I mean,
to issue Sagavali chit.
Yes. So I prefer my representation on 30/6/2022, that is at annexure G. But after this, they issued endorsement annexure A, alleging that in view of circular dated 9/6/2014, I am not entitled to Savole, alleging that our land is comes within the 25 kilometers from the
18 kilometers.
18 kilometers from the radius of the municipality. So this circular is not applicable to our case because much earlier to this act coming into force on 6/8/2018, the land has been granted to me on 31/8/2015 itself. 31/8/2005 alone granted is circular number applicable.
Not the circular, sir. There is a provision of law. Please see section 94 capital A. There is a provision. There is a prohibition contained in the provision. It is not by virtue of a circular issued by the government.
But by virtue of the circular,
it is not by virtue of the circular. It's by virtue of the provision of law, sir. But you can only contend when the land to the neighboring persons were granted, how they could make use of this circular only to deny you the grant. That is your argument. Barkali. Have they cancelled all the other grants made in favor of the other person? Yes. Learned AGA takes notice for all the respondents. Learned counsel for the petitioner is directed to serve a copy of the petition on the learned AGA. Next para. The petitioner is that although the Committee for Regularization of Unauthorized Occupation recommended grant of 22 guntas of land in favor of the petitioner in a resolution dated 31/8/2005, till date, Sagoli chit has not been issued by the Tahsildar. So, earlier, the petitioner was before this court in WP number 8628 of 2022. The same prayer. So, this court by order dated 30th of May 2022 permitted the petitioner to make one more representation to the Tahsildar, Bangalore North Additional Taluk. And the Tahsildar was directed to consider the representation and pass necessary orders within an outer limit of 3 months. Stop. Learned Counsel for the petitioner submits that on a representation being given by the petitioner, the Tahsildar has issued the endorsement dated 1/7/2022 at Annexure A, declining to issue Sagoli chit to the petitioner on the ground that the land in question falls within the prohibited distance of 18 kilometers. And in terms of the circular, government circular, dated government circular bearing number 168 LGB 2014, dated 9/6/2014, the land cannot be granted to the petitioner. Stop. Learned Counsel submits that when admittedly Sagoli chits have been issued to all the neighboring grantees, and their lands also are situated at the same distance, the Tahsildar could not have issued the impugned endorsement, simply based on a circular issued by the state government. Stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned. ಮತ್ತೆ ಏನ್ ಕೇಳ್ತೀರ? ವಾಟ್ ಇಸ್ ಇಟ್ ದಟ್ ಯು ಆರ್ ಆಸ್ಕಿಂಗ್?
ಇಶ್ಯೂ Sagoli chit ಅಷ್ಟೇ. Representation ಮಾಡಿದ್ರೆ
ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ತೆಗೆದ್ಬಿಡಿ. ಅಲ್ಲಿ ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲಿ ಶೆಲ್ ಸರ್ವ್ ಎ ಕಾಪಿ ಆನ್ ದಿ ಲರ್ನಡ್ AG ಅಂತ ಹೇಳಿದ್ನಲ್ಲ, ಅದನ್ನು ತೆಗೆದ್ಬಿಡಿ. ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಬರ್ಕೊಳ್ಳಿ. There is substance in the contention of the learned counsel for petitioner. Stop. If Sagoli chits have been issued to the neighboring landowners who were also granted lands by the committee in terms of the order dated 31/8/2005, then it does not the Tahsildar or the state government say that the land cannot be granted to the petitioner and Sagoli chit cannot be issued. It's another matter if the state government or the concerned revenue authority, that is the assistant commissioner, has initiated proceedings to cancel all the grants made in favor of the grantees in terms of the order of the committee dated 31/8/2005. Stop. However, comma, it does not appear so, comma, since it is contended by the petitioner that no such action has been taken by the state government to cancel the grants made in favor of the neighboring landowners. Full stop. Next para. Consequently, the writ petition stands disposed of while setting aside the impugned endorsement dated 1/7/2022, comma, directing the Tahsildar, Yelahanka Taluk, to reconsider the grievance of the petitioner. Full stop. The Tahsildar shall secure records, find out if the grants made consequent to the order dated 31/8/2005 passed by the committee have been recalled or cancelled. Stop. If no such action has been taken by the state government or the assistant commissioner to cancel the grants, comma, then the petitioner is also entitled for issuance of Sagwali chit in terms of the order passed by the committee on 31/8/2005. Stop. Next para. The Tahsildar is hereby directed to verify the records, comma, and if it is found that the grants made in favor of the neighboring landowners have not been cancelled, comma, then the Tahsildar shall issue a Sagwali chit to the petitioner as expeditiously as possible and at any rate within a period of 2 months from the date of receipt of a copy of this order. Stop. Ordered accordingly.
Of mandamus lordship. The Chika Revanna is the original grantee, husband of the petitioner lordship. The order dated 8/3/1981.
Representation.
Presentation I have given 2 times your
ಏನಂತ?
ಖಾತಾ ಮಾಡ್ಕೊಡೋದಕ್ಕೆ
ಹಾ?
ಖಾತಾ ಮಾಡ್ಕೊಡೋದಕ್ಕೆ ನನ್ನ ಯಜಮಾನ ತೀರ್ಕೊಂಡ ಮೇಲೆ
ಹಾ.
ಅವ್ರ ಹೆಸರು ಖಾತಾ ಆಗಿರ್ಲಿಲ್ಲ. ಇಮಿಡಿಯೇಟ್ಲಿ ಗ್ರಾಂಟ್ ಆಫ್ಟರ್ ದಟ್ he has died in
Grantee.
1807.
Chikkarevana was granted in the year 1981.
Please not.
ಅದಾದ್ಮೇಲೆ
also issued on 14/3/1982.
ಹಾ.
After that he has filed the representation before the consent authority to
died in the year 1987.
ಹೌದು.
ಹಾ, ಅಂದ್ರೆ ಅವರ ಹೆಸರು ಲ್ಯಾಂಡ್ ರೆವೆನ್ಯೂ ಎಂಟ್ರಿ ಆಗ್ಲಿಲ್ಲ.
ಆಗಿಲ್ಲ. After that she approached several times she approached and Ramnagara district was established lordship. Subsequently filed in 2016 also. They have not considered and immediately on 7/7/2020 also she filed the representation to effect the khata, giving the entire document. ಇವ್ರ ಜೊತೆ ಗ್ರಾಂಟ್ ಆಗಿರೋರಿಗೆ ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ಖಾತಾ ಆಗಿದೆ. ಈಗ ಇವ್ರಿಗೆ ಆಗಿಲ್ಲ. Of that I felt the present mandamus directed the Tahsildar to effect khata in the name of the petitioner.
Perfect. Learned AGA. Take both the respondent. Learned counsel for the petitioner is directed to serve a copy of the petition on the learned AGA. Next para. Since the grievance of the petitioner is that her name is not being entered in the land records, although she is legitimately entitled to have her name entered consequent to a grant said to have been made in favor of the petitioner's husband, Shri Chikka Revanna, on 8/3/1981, and a grant certificate dated 14/3/1982 was also issued in favor of Shri Chikka Revanna. The learned ATA is directed to secure instructions from the second respondent Tahsildar, Bangalore South Taluk, as to why the grievance of the petitioner is not being redressed. List this matter after Dasra vacation. Uh, 2009. I disposed of.
Yes. Next case, I've called in question the order of the Deputy Commissioner passed under section 163 of the Taylor Act. Lord, in fact, the petitioner is the owner in possession.
Who approached the Assistant Commissioner?
Lord, it is the respondents who approached, it is the petitioner who has approached the Assistant Commissioner.
Where is that order?
Lord, page number 49, annexure K, Lord. May I take your lordships to page number 50.
Mahadev.
Installation.
You approached the Assistant Commissioner.
Yes, Lord, I have approached the Assistant Commissioner.
Questioning what?
Lord, the Khata may have to be made in my name. Lord,
Questioning what, sir?
Assistant Commissioner have passed an order in my favor.
Sir, you questioned what? By filing an appeal.
Yes, Lord, I have questioned the MR made in favor of the respondents.
MR number?
MR number 1 of 2017-18, Lord, which is at annexure J, Lord. That is called in question, wherein the respondent's name are mutated with respect to the land bearing survey number 77/4, measuring 1 acre 30 gunters. And that was called in with respect to 1 acre, I called in question. And that, Lord, the Assistant Commissioner have allowed the appeal filed by me. Vishleshana is at page number 53. May I take your last to Vishleshana?
Yes.
Paragraph number 3, Lord, in that.
No, you read from paragraph 1.
ಮೈಸೂರು ತಾಲೂಕು ವರ್ಣ ಹೋಬಳಿ ಚಿಕ್ಕಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 77/4 ವಿಸ್ತೀರ್ಣ 1 ಎಕರೆ 32 ಗುಂಟೆ ಜಮೀನು ಪೈಕಿ 2 ರಿಂದ 9ನೇ ಎದುರುದಾರರ ಹೆಸರಿಗೆ ಖಾತೆ ದಾಖಲಾಗಿರುವ ವಿಸ್ತೀರ್ಣ 1 ಎಕರೆ ಜಮೀನಿನ ಪೈಕಿ 38 ಗುಂಟೆ ಜಮೀನು ಸದರಿ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದೆ. ರೆಕಾರ್ಡ್ ಆಫ್ ರೈಟ್ಸ್ ದಾಖಲಾತಿಯ ಕ್ರಮ ಸಂಖ್ಯೆ 156ರಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 177/4ಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಖಾತಾದಾರ ಕುಂಬಶೆಟ್ಟಿ ಬಿನ್ ಕಾಳಶೆಟ್ಟಿರಾಗಿರುತ್ತಾರೆ. ಹಾಗೆಯೇ ರೆಕಾರ್ಡ್ ಆಫ್ ರೈಟ್ಸ್ ದಾಖಲೆ ಕ್ರಮ ಸಂಖ್ಯೆ 157ರಂತೆ ಸರ್ವೆ ನಂಬರ್ 77/5ಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಖಾತಾದಾರ ಚೌಡಶೆಟ್ಟಿ ಬಿನ್ ಹೊನ್ನಶೆಟ್ಟಿ ರವರಾಗಿರುತ್ತಾರೆ. ಮೇಲ್ಮನವಿದಾರರು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸುವ ಹಿಸ್ಸಾ ಸರ್ವೆ ಟಿಪ್ಪಣಿ ದಾಖಲೆಯಂತೆ 77/4ರ ಖಾತಾದಾರ ಹೊಂಬಶೆಟ್ಟಿ ಬಿನ್ ಕಾಳಶೆಟ್ಟಿ ಹಾಗೂ ಸರ್ವೆ ನಂಬರ್ 77/5ರ ಖಾತಾದಾರ ಚೌಡಶೆಟ್ಟಿ ಬಿನ್ ಹೊನ್ನಶೆಟ್ಟಿ ಆಗಿರುತ್ತಾರೆ. ಮೇಲ್ಮನವಿದಾರರು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಿರುವ ದಿನಾಂಕ 7/8/1968 ದಾಸ್ತಾವೇಜು ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಕ್ರಯಪತ್ರವನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಚಿಕ್ಕಹಳ್ಳಿ ಗ್ರಾಮದ ಚಿಕ್ಕ ವಡಗಲ್ ಶೆಟ್ಟಿರವರ ಮಗ ರಂಗಶೆಟ್ಟಿ ಮತ್ತು ಈತನ ಹೆಂಡತಿ ಮರಮ್ಮ ರವರಿಗೆ ಹೊಂಬಶೆಟ್ಟಿ ಬಿನ್ ಕಾಳಶೆಟ್ಟಿ ಮತ್ತು ಈತನ 1ನೇ ಮಗ ರಂಗಶೆಟ್ಟಿ ಹಾಗೂ 2ನೇ ಮಗ ಹೊಂಬಶೆಟ್ಟಿ 3ನೇ ಮಗ ಚೌಡಶೆಟ್ಟಿ 4ನೇ ಮಗ ಮರಿಶೆಟ್ಟಿ ಅವರು ಸರ್ವೆ ನಂಬರ್ 77/5 ಕೋಡಿಯಲ್ಲಿ 1 ಎಕರೆ 30 ಗುಂಟೆ ಜಮೀನನ್ನು ವಿಕ್ರಯಿಸಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ.
So this Hombashetti has sold it to you.
Yes, my lord.
Hombashetti
He was actually owner of survey number 77/4. In the sale, it is wrongly mentioned as 77/5. ಅದನ್ನ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 8 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ.
ಚಿಕ್ಕ ವಡಗಲ್ ಶೆಟ್ಟಿರವರ ಮಗ ರಂಗಶೆಟ್ಟಿ ಮತ್ತು ಈತನ ಹೆಂಡತಿ
ಪರಮ್ಮರವರಿಗೆ ಹೊಂಬಶೆಟ್ಟಿ ಮಗ ಕಾಳಶೆಟ್ಟಿ ಮತ್ತು ಈತನ 1ನೇ ಮಗ ರಂಗಶೆಟ್ಟಿ.
ಹೊಂಬಶೆಟ್ಟಿ ಮಗ ಕಾಳಶೆಟ್ಟಿ ಅಂತ ಅವ್ರ ಮಗ ಕಾಳಶೆಟ್ಟಿನ
ಹೊಂಬಶೆಟ್ಟಿ ಮಗ ಕಾಳಶೆಟ್ಟಿ ಮತ್ತು ಈತನ
ಹೊಂಬಶೆಟ್ಟಿ ಸನ್ ಆಫ್ ಕಾಳಶೆಟ್ಟಿ ಅಂತ. So the ಖಾತೆದಾರ only has sold it.
ಖಾತೆದಾರ have only sold it to me
in the year 1968.
In the year 1968. Well, what had happened is adu well thereafter that Maramma and Chikkaputta Shetty have sold it to me. Well, paragraph number 5. I will read paragraph number 5 also.
One ನಿಮಿಷ. First paragraph ಅಲ್ಲಿ
yes,
what was the extent of holding of Hombashetti?
Well, 1 acre 38 guntas. 1 acre 38 guntas.
32 guntas, sorry, 32 guntas. 1 acre, 32 guntas. Hajar Madin, annexure B again.
1 acre 32 guntas.
Yes, my lord.
What was sold to you? 1 acre 30 guntas.
1 acre, 30 guntas.
You purchased from this
Ranga Shetty, Madha Shetty and Maramma.
Ranga Shetty and Maramma.
Yes, my lord. I have purchased through 2 sale deeds. One measuring 38 guntas and another measuring 32 guntas. This is paragraph number 5 and 6. Now, my lord, your lordship may kindly come to paragraph number 8, my lord. May take your lordship paragraph number 8, my lord. ವಿಶ್ಲೇಷಣೆ ಗಣಿಕೆ 3, 4, 5 ಮತ್ತು 6 ತಿಳಿಸಲಾಗಿರುವ ಕ್ರಯಪತ್ರಗಳು ಹಾಗೂ ಭೋಗ್ಯ ಪತ್ರಗಳ ಪರಿಶೀಲನೆ ಮಾಡಲಾಗಿದೆ.
Purchased in 1970, 71.
70, 71.
Then
your name was not entered. Your
name was not entered in the land record.
With respect to 38 guntas, it was entered. So far as 32 guntas, it was not entered.
1 acre.
But
32 guntas, it was entered. 1 acre, it was not entered.
it was not entered.
Yes,
sir. So therefore, my lord, now my lord, your lordship may kindly come to paragraph number 8 for a while, my lord.
Yes.
ವಿಶ್ಲೇಷಣೆ ಖಂಡಿಕೆ 3, 4, 5 ಮತ್ತು 6 ತಿಳಿಸಲಾಗಿರುವ ಕ್ರಯಪತ್ರಗಳು ಹಾಗೂ ಭೋಗ್ಯ ಪತ್ರಗಳನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಲಾಗಿ ಮತ್ತು ವಿಶ್ಲೇಷಣೆ 2ರಲ್ಲಿ ತಿಳಿಸಿರುವಂತಹ ರೆಕಾರ್ಡ್ ಆಫ್ ರೈಟ್ಸ್ ದಾಖಲಾತಿಯನ್ನು ಗಮನಿಸಲಾಗಿ ಹೊಂಬಶೆಟ್ಟಿ ಬಿನ್ ಕಾಳಶೆಟ್ಟಿ ರವರಿಗೆ ಚಿಕ್ಕಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 77/4 ಹಕ್ಕಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಆದ ಕಾರಣ ಈ ಮೇಲಿನ ವಿಶ್ಲೇಷಣೆಯ 3, 4, 5 ತಿಳಿಸಿರುವ ಕ್ರಯಪತ್ರಗಳಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 77/4 ಎಂದು ನಮೂದಾಗುವ ಬದಲಾಗಿ 77/5 ಎಂದು ನಮೂದಾಗಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಏಕೆಂದರೆ ಹೊಂಬಶೆಟ್ಟಿ ಮಗ ಕಾಳಶೆಟ್ಟಿ ಮತ್ತು ಇದರ ಮಕ್ಕಳು ಜಂಟಿಯಾಗಿ ಮರಮ್ಮ ಮತ್ತು ರಂಗಶೆಟ್ಟಿ ಚಿಕ್ಕಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 77/5ರಲ್ಲಿ 1 ಎಕರೆ 30 ಗುಂಟೆ ಸ್ವತ್ತನ್ನು ವಿಕ್ರಯಿಸಿರುವ ಕಾರಣ ಸರ್ವೆ ನಂಬರ್ 77/4ರಲ್ಲಿ ತಮಗೆ ಇದ್ದಂತಹ ಹಕ್ಕನ್ನು ರಂಗಶೆಟ್ಟಿ ಮತ್ತು ಮರಮ್ಮನವರಿಗೆ ಕ್ರಯಪತ್ರ ಮೂಲಕ ಮಾರಾಟ ಮಾಡುವ ಕಾರಣ ಕಳೆದುಕೊಂಡಿರುತ್ತಾರೆ. ನಾವು ನನಗೆ ಸೇಲ್ ಡೀಡ್ ಆಗುವಾಗ 77/5 ಅಂತ ಬರ್ಬಿಟ್ಟು ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಫಸ್ಟ್ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಎಲ್ಲಾ ಸೇಲ್ ಡೀಡ್ 77/5 ಅಂತ ಬಂದ್ಬಿಟ್ಟು. But this original vendor, in whose name the Paslupani annexure deed which I have given, was owner of 77/4. Now, my lord, the respondents are claiming to the original vendor, that is, our makkalu anta heli ivaru hesaru khate koosಕೊಂಡಿದ್ದಾರೆ.
Because wrong survey number issue.
Wrong survey number was issued. Now, my lord, observing that the district commissioner have rightly allowed my appeal.
How can you allow?
My lord,
how can you allow, sir?
My lord,
unless you get a rectification of the sale deed, rectification of the survey number in the sale deed at the hands of the civil court, how could he pass this order?
Originally,
so the deputy commissioner has
deputy commissioner have reversed it. Reversed it. Now, my lord, 71 sale deed. It is 1968 is the first sale deed. 1971 is the second sale deed. DC
deputy commissioner is right.
Yes, my lord.
Then
suit
file ಮಾಡಿದಿರಾ? suit file ಮಾಡಿದಿರಾ?
Suit for bare injunction was filed. Suit for bare injunction is filed.
ಅದೇನು ಪ್ರಯೋಜನ ಆಗೋದು?
ಬರೋದಿಲ್ಲ.
Learned AGA takes notice for response number 1 to 4. Issue emergent notice to response number 5 to 12. Learned comes for the petitioner directed to serve a copy of the petition on the learned AGA. Yes.
Yeah.
Yes.
I'm appearing for serial number 9, my lords. I'm appearing for the petitioner.
ಎಲ್ಲರಿಗೂ ಹಾಕಿದಾರಾ? 5 to 7.
Yes.
ಅಲ್ಲಿ learned counsel Sri G. Nagendra has entered appearance for response number 5 to 7. Issue emergent notice to
8, 9, 10, 7.
response number 8 to 11.
8 to 12.
8 to 12. Yes.
Please, my lord, I'm appearing for the petitioner, my lords. That's in this case,
Yes.
my lords, in this case, my lords, the petitioner, father of the petitioner has purchased the land bearing survey number 1/10, new number 21/1. in the year 1966, my lords.
Grandfather of the petitioner.
Yes, yes,
Under sale deed.
yes, my lord. 60s and as per next year. Amen. Then it
Yes.
was granted land, my lord. Therefore, they approached the Assistant Commissioner. Assistant Commissioner has passed the order. It is vested with the government. Thereafter, filed the writ petition as per Annexure C, my lord. The writ petition was dismissed and filed the application for recalling that order Annexure D, my lord. The Annexure D, my lord, in page 30, made an observation.
In page
30, my lord.
30.
Yes, ma'am.
1988.
Yes, my lord. Then they are the my lords in this IA, my lord, they have disposed the IA, made an observation. May I read it, my lords?
What was the prayer in that writ petition?
My lord, setting aside the order passed by the Assistant Commissioner, which was rested with the government.
Watching the order at Annexure C dated so passed by Special Deputy Commissioner. That PTCL Act.
Yes, my lords, it was vested with. Thereafter, approached this honorable court.
PTCL
my lord,
Act, sir.
Yes, yes.
PTCL Act who initiated proceedings?
My lords, the Assistant Commissioner, Annexure B, my lords.
Tatanahalli Nanjayya. Tatanahalli Nanjayya. He initiated proceedings and under the PTCL Act, is it?
Yes, my lord.
Yenaito?
It was vested with the government. Then, my lord, approached this honorable court, my lord, as per Annexure C. It was writ petition was dismissed and filed the application for recalling, my lord, as per Annexure D.
That application also is dismissed.
Dismissed, but made such observation that since the petitioner, the purchaser is residing there, they constructed the residential house upon some portion of the land, and he
So
has
only to
raised
permit it to harvest.
Yes, but thereafter,
Permitted
if they are if they are residing, they let them permit ಅಂತ ಹೇಳಿದ್ರು.
ಅದೆಂಗಾಗುತ್ತೆ?
ಅಲ್ಲ, ಈ observation is made. ಅಲ್ಲ, ಮಾಡಿದ್ದಾರೆ. Thereafter, my lord, at their understanding, they exchange the land.
Please read it, madam. Please read page number 31.
Yes, IA is rejected. However, the Assistant Commissioner is directed to draw a measure in indicating the actual improvement of the affected of the land by the petitioner after the sale was made in his favor. Secondly, if there is any standing crops raised by the petitioner may be permitted to harvest the same. Thirdly, if there is a dwelling house as submitted before me by the learned counsel for the petitioner, his family, if there is residing, it shall be allowed to remain there undisturbed. When they are residing, as they have drawn the measure, they are residing there, therefore they are permitted. Then they have made an exchange deed themselves between this the grantee and the purchaser. To the same extent, some other servant 37/1, the land is exchanged to that grantee, and they were cultivating the said land. Then I produced the RTC.
ಯಾವ document? Which is that
Exchange
document?
deed I produced. Yes, I produced the Annexure E, my lords.
Annexure E. Annexure
Yes,
E is only an affidavit.
In the form of that, they have exchanged the land, my lord. That is under yes, my lord. Yes, my lord.
ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
That in the village, my lord, they have made arrangement. After when they are residing there, they have made arrangement. Then they were cultivating there 37/1, the grantee and this purchaser are cultivating the said land till today. I produced the RTCs, my lord, till 2021. Produced at Annexure FGH, my lords.
ಸರಿ.
Now, my lords, without issuing any notices, my lord, they have cancelled the entries. If they issued notice, my lord, both the parties will appear before the Assistant Commissioner, my lord, will say, it is our arrangement, we are cultivating the land by exchanging them. Without issuing any notice, my lord, only on the basis of letter issued by the Tahsildar. Yes, pass the order and cancel all the entries and
Office of the Assistant Commissioner, Annexure
Yes.
J. If the land was directed to be resumed and resumed in favor of the government, where is the question of the grantee allowing you to continue to be in occupation?
But the grantee has the in the village, my lord, they themselves both have made
The order of
arrangement.
the assistant commissioner is to resume the land in favor of the government.
And the restore it, then the handed over to the grantee, my lord.
ಎಲ್ಲಿದೆ?
ಅಲ್ಲಿ
ನೀವೇ ತಾನೇ
assistant
ಹೇಳಿದ್ದು. I do not know. Please show. Where is that order?
that annexure ಏದಲ್ಲಿ ಅದು ಇದರಲ್ಲಿ ಇಂಪ್ಯೂಂಡ್ ಆರ್ಡರ್ ನಲ್ಲೇ ಹೇಳಿದಾರೆ ಮತ್ತೆ ರದ್ದುಗೊಳಿಸ ನಮೂದಿಸಿ ತದನಂತರ ಮೂಲ ಮಂಜೂರ ವಾರಸುದಾರರಿಗೆ ನೇಮಾಸರ ಖಾತೆ ತಹಸೀಲ್ದಾರ್ ಹೆಚ್ಚುಕೊಳ್ಳುವ ಆದೇಶಿಸಿದೆ.
ಹಾ ಹಾ
They issued notices, my lord, for both the parties, my lord, we would appear and say all these things, my lord, developments. Since 66, he has developed the land, they have made exchange between themselves. Only on the basis of the letter of the Tahsildar, my lord, he has passed this order. Now they are residing there, my lord, their dwelling house is there. Since 66, they have constructed the house upon some portion of the land, my lord. After lapse of 50 years, my lord, now they are without issuing any notices.
So it is only the official memorandum dated 16/6/2022
Yes, my lord.
that is under challenge.
Yes, my lord.
Huh?
Yes, my lord. 16/6/22.
30th August 1982, that order has attained finality.
ಅದೇ ಅದು ಇದ್ರದ್ದು ಅದು PTC ಅಲ್ದು ಆಯ್ತು.
Position ಅಷ್ಟು protect ಮಾಡಿದ್ದಾರೆ. Rather merger, harvest the crop, don't disturb from the position of the house.
ಅಲ್ಲ ಅದಾದ್ಮೇಲೆ there has been some transaction between the original grantee.
Prior to that.
No.
ಆಮೇಲೆ
there is an affidavit. ಪ್ರಮಾಣ ಪತ್ರ. So
59 ದಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ ಪ್ರಮಾಣ ಪತ್ರ.
Correct. But how it can be resumed to the government? In PTC ಹೌದು. Initially it is to be resumed to the government, thereafter restored in favor of the original grantee or legal heirs. ಅವರೇ ನಿಮ್ಮ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಹೇಳಿದಾರೆ ಅವ್ರ ಆರ್ಡರ್ ಅಲ್ಲಿ. How could it be resumed to the government now? ಮೂಲ ಮಂಜೂರಿದಾರರ ವಾರಸುದಾರರಿಗೆ ನಿಯಮಾನುಸಾರ ಖಾತೆ ತಹಸೀಲ್ದಾರ್ ಎಸ್ ಟಿ ಕೋಟೆ ಅವರಿಗೆ ಆದೇಶ. AGA takes notice for response number 1 to 4. Issue emergent notice to respond to 5. Learned counsel for the petitioner is directed to serve a copy of the petition on the learned AGA. List this matter immediately after.
Kind permission. Not to dispose from that.
Till the next date of hearing, the respondent authorities are directed not to dispose the petitioner. Yes.
Representation to the Tahsildar to the Kata annexure J is the representation.
Consider.
Number 43.
What is the
See,
basis of your claim?
annexure D. Annexure D ದಲ್ಲಿ. ಈ ವಿಷಯದಲ್ಲಿ bill
Ah.
On that basis, they have given the basis, based on the will they have approached and obtained the. Number 24. Wait. What is directed to issue? Based on that, based on the will they are seeking. And section J is the representation. That is required. Not just the link.
Probate was granted when?
Before. It's on 3/2021.
1/3/2021. And you gave a representation
On 19/9/2022.
19/9/21. What is this endorsement at Annexure H? You gave a complaint, is it?
Yes, ma'am.
Against the Tahsildar?
Yes, ma'am. Because
Huh?
I gave a representation to page number 37. It's kindly see.
Huh?
Annexure F, please. Gave a representation on 28/7 of 2021. madam.
Hmm.
On probate order.
Huh?
They are ನಾವು ಹೋದ್ವಿ ಅವ್ರು ಕೇಳಿದಕ್ಕೆ ಇಲ್ಲ ಅಮೌಂಟ್ ಕೊಡಿ ನಾವು ಇದ್ ಮಾಡ್ಕೊಡ್ತೀವಿ ಅಂತ
Hmm.
ಅದಕ್ಕೆ
So you gave a complaint against the Tahsildar?
Yes, ma'am.
In spite of that, he has not done anything.
ಅವತ್ತಿಂದ ಏನ್ ಮಾಡ್ತೀವಿ ಆರ್ಡರ್ ನಮ್ ಫೇವರ್ ಬರೋದಿಲ್ಲ ಏನು ನಮ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಒಂದಕ್ಕೂ ಕನ್ಸಿಡರ್.
Same person is there, is it? Tahsildar, ಅವರೇ ಇದ್ದಾರಾ? ಅವರೇ ಇದ್ದಾರಾ?
ಚೇಂಜ್ ಆಗಿದೆ.
Huh?
ಹೊಸಬ್ರು ಇದ್ದಾರೆ.
ಶಿವರಾಜ್ ಅಂತ.
ಹೊಸಬ್ರು ಇದ್ದಾರೆ.
ಬರ್ಕೊಳ್ಳಿ. Lord AGA takes notice for the respondent Tahsildar, Devanhalli Taluk.
Yes, ma'am.
Next para. The grievance of the petitioners is that in spite of there being a probate of the will dated 10/11/2016 left behind by Sri R.M. Imegowda, son of Ishamappa, bequeathing history.
2 acres.
Huh?
2 acres.
Where do you get that?
Page number 5.
Huh?
Tara, page 25, order of this.
Page number 41 is the RTC.
Testator is the grandfather of the petitioner. Petition scheduled properties are the lands bearing survey number 92 bar.
1 acre out of 2 acres. Bequeathing 1 acre of land in survey number 92 bar P10 of Kosalli village, Chandrayapatna Hobli, Bangalore. Huh? Bangalore rural district. Bangalore rural district. ದೇವನಹಳ್ಳಿ ತಾಲೂಕು ಅಂತ ಬರ್ಲಿಲ್ವಲ್ಲ ಇಲ್ಲಿ?
ದೇವನಹಳ್ಳಿ ತಾಲೂಕು.
ದೇವನಹಳ್ಳಿ ತಾಲೂಕು.
ದೇವನಹಳ್ಳಿ ತಾಲೂಕು ಬೆಂಗಳೂರು ರೂರಲ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್.
ದೇವನಹಳ್ಳಿ ತಾಲೂಕು Bangalore rural district. In favor of the petitioner, who is the grandson.
Yes, ma'am.
And several representation being given to the Tahsildar to carry out the mutation entry in the land records. The Tahsildar has not carried out the mutation entry. Stop. Next paragraph. Then counsel for the petitioner submits that a complaint was also lodged by the petitioner against the previous Tahsildar before the Anti-Corruption Bureau, Bangalore, and the said Tahsildar was said to have been transferred, and an endorsement dated 18/9/2021 was given by the Superintendent of Police, Anti-Corruption Bureau, Bangalore Rural District, to the petitioner. Full stop. However, the grievance of the petitioner is still not redressed. Stop. The petitioners have given one more representation dated 19/9/2022 at annexure J to the respondent Tahsildar. Stop. Next paragraph. Having regard to the prayer made in the petition and the fact that a probate has been granted by the competent civil court in respect of the registered will dated 10/11/2016, left behind by Sri R.M. Timmegowda, who was the owner of the land in question, bequeathing 1 acre of land in favor of the petitioners. Petitioners Ibru idara? Ibru parvagi Ibrugu ಸೇರಿಸಿ 1 ಎಕರೆ.
2 ಎಕರೆ ಇರುತ್ತೆ.
ಹಾ?
2 ಎಕರೆ. RTC ಅಲ್ಲಿ
ಇಬ್ರಿಗೂ 1 ಎಕರೆನಾ?
ಇಬ್ರಿಗೂ 1 ಎಕರೆ ಮಾಡಬಹುದು.
ಹೇಳಿದೆ?
I will refer to the prayer made in the petition and the fact that the competent civil court in respect of the registered bill dated 10/11/16 left behind by Sri R.M. Timmegowda,
Bequeathing
the owner of the land in question, bequeathing 1 acre of
1 acre each. 1 acre each in favor of the petitioner's parent. The respondent Tahsildar is duty bound to consider the representations given by the petitioner. Stop. Next paragraph. Consequently, the writ petition stands disposed of with a direction to the respondent Tahsildar, Devanhalli Taluk, to consider the representations given by the petitioners and having regard to probate issued by the competent civil court in P&SC number 15020 of 2020 dated 1st of March 2021, the Tahsildar shall proceed to effect mutation entry of the names of the petitioners in accordance with the probate certificate granted by the civil court. Stop. The mutation entry orders shall be passed and carried out as expeditiously as possible and at any rate in a period of 2 months from the date of receipt of a copy of this order. That person is not there.
No.
Huh?
He's dead in the year 2007.
Aye. 79 AB.
Please, yes. Great.
Yes. ಏನಾಯ್ತು ಲ್ಯಾಂಡ್ ಲೂಸರ್ಸ್ ಅದೇಮ್ಮ their lands were submerged, so they are land losers only.
From the date of filing of their anticipated position. If anybody is I wanted to write because it's following the grantee is the question of the land. It's a land what subject to be one. That's not.
There was a contempt petition filed. ಆದೇಶದಂತೆ ಕೊರತೆ ವಿಸ್ತೀರ್ಣ ಗುರುತಿಸಿ ವರದಿಸಲು first petitioner is the person in whose favor this order was passed. Even what was granted, she has already sold in violation of the conditions. Then, ಇವಾಗ ಯಾರು ಗ್ರಾಂಟ್ ಮಾಡಬೇಕು ಅಂತ ಕೇಳ್ತಾ ಇರೋದು ನೀವು? ಯಾರು ಗ್ರಾಂಟ್ ಮಾಡಬೇಕು? How can it be granted to the second petitioner? What right? No. What right does he have to claim a regrant of? Hmm. 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 No, we'll consider. Learned AGA takes notice for all the respondents. Learned counsel for the petitioner direct serve a copy of the petition on the learned AGA. Statement of objection shall be filed within a period of 2 weeks from today. If Mr. Jose is in possession, he is definitely to be evicted. Yes.
Conversion 5/3/2022. Adildar, State Commissioner also filed a report.
You know,
It's before the
he applied for conversion.
conversion of a land.
Ah.
On 5/3/2022. Even after 5 months,
No orders are.
orders passed. And I gave a representation also on 5/8/2022. Still not considered. And
There is a deeming provision.
and under 95(5).
So what is your prayer?
To issue a conversion certificate.
You are not asking for a declaration that there is a deemed.
I asked page 11.
Was it?
Issue a writ of mandamus directing the respondent number 2 to declare that the land survey number 172
as deemed to have been converted.
Deemed to have been converted from agriculture.
Yes, sir.
Covered. Covered.
If no endorsement is given, no objections are raised, or some clarification is sought, then in terms of the provision, it should be a deemed declaration. No, let us see. Learned AGA takes notice for both the respondents. Learned counsel.
Latest computer report
serve a copy of the petition on the learned AGA. Next para. Since the claim made by the petitioner is that there should be a declaration of deemed conversion. In terms of section 95(5) of the Karnataka Land Revenue Act number 1964, learned AGA is directed to secure instructions from the second respondent, Deputy Commissioner, Kolar District, as to whether the application filed by the petitioner has been considered and any orders passed or any clarification was sought by the Deputy Commissioner. Full stop. List this matter immediately after Dasra vacation.
I have given the representation to Tahsildar to change Khata. The representation is page number 32, my lords.
Please come to the synopsis.
Petitioner
Dodda Muniappa purchased.
Yes, my lord. Petitioner father, Muniappa. He has purchased the property in year 2007 and executed the gift deed in favor of the petitioner who is son, my lord.
2008 ಅಲ್ಲಿ.
Yes, my lord. Now I am requesting to change the khata.
Why?
In favor of me.
2008 ಇಂದ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
I have given the representation earlier, my lord. But it has not been, I don't have acknowledgement, my lord. So I have given the recently, my lord. And got acknowledgement, I am before this court.
Where is the sale date?
Sale date, my lord, is in page number, my lord, 13.
5/1/2007.
Mutation register is in.
Have you produced a copy of the RTC?
Yes, my lord.
ಯಾರ ಹೆಸರಲ್ಲಿದೆ?
Page number 35, Dodmuniappa.
ಹಾ?
Dodmuniappa, father of the petitioner.
ಅವ್ರ ಹೆಸರಲ್ಲಿ ಇದೆಯಾ?
Yes, my lord.
What is the difficulty then?
Anita F, my lord, page number 35.
Computerized.
Computerized RTC ಇದೆಯಲ್ಲ?
MR number 19 of 2006-7 number.
In the that
Very soft.
ಅಲ್ಲ ಅದ್ಯಾವುದೋ ಒಂದು ಸ್ಟ್ಯಾಚ್ಯೂಟ್ ಏನೋ ಆಕ್ಟ್ ಏನೋ ಮಾಡಿದ್ರಲ್ಲ ಫಾರ್ ದಿ ಟೈಮ್ಲಿ ಡಿಸ್ಪೋಸಲ್ ಆಫ್ ಆಲ್ ದಿ ಅಪ್ಲಿಕೇಶನ್ ಸಕಾಲ ಅದ್ರಲ್ಲಿ ಇದೆಲ್ಲ ಇಲ್ವಾ? Then how is it that they don't pass any order?
This Regularization imposed cost in one of the cases when I was contempt for Sakal delay and I'll assert it. Now his father's name is there. What is that? MR number 19.
I can understand ಕೈ ಬರಹದ ಪಾಣಿಗಳಿತ್ತು, ಅದು it could be manipulated, all that is all right. But here there is a computerized ಖಾತಾ.
MR G.
ಇದೆ, ಎಲ್ಲ ಇದೆ.
MR also stands in name of father. Can do in 4 weeks. Based on this.
Learned AGA takes notice for the respondent, Tahsildar, Shidlughatta Taluk. Next para. When it comes for the petitioner submits that the petitioner herein acquired the land in question measuring 3 acres. Purtina 3 acres in survey number 7/P5 of Dodadasarahalli, Kasaba Hubli, Shidlughatta Taluk under a registered gift deed dated 29/2/2008. Executed by his father, Shri Dodda Muniappa. Stop. Learned Council submits that Shri Dodda Muniappa purchased the land in question under a registered sale deed dated 5/1/2007 and his name has been entered in the land records consequent to mutation order in MR number 19/2006-2007 at annexure G. Stop. The petitioner has also produced a copy of the computerized RTC of the year 2011-12, which shows the name of Shri Dodda Muniappa entered in column number 9 and in column number 10, the mutation carried out in MR number 19/2006-2007 as per sale deed dated 2/4/2007 is also reflected. Stop. Then council submits that in spite of a registered gift deed having been executed by Shri Dodda Muniappa in favor of the petitioner herein, and several representations are given to the respondent Tahsildar. Even on the writ petition hakidra.
Repetition.
What is this 22/9/2022 ido e writ petition? Elda?
Submitted in spite of a registered gift deed have been executed by Shri Desanamasa in favor of the petitioner and the several representations are given to the respondent Tahsildar.
Tahsildar, the Tahsildar has not passed any orders. Stop. Next para. In the considered opinion of this court, the respondent Tahsildar is duty bound to consider the representation filed by the petitioner, and in terms of section 128 of the Karnataka Land Revenue Act, 1964, the petitioner is entitled to have his name mutated in the land records on the strength of a registered gift deed executed by the previous owner, that is the father of the petitioner. Stop. Next para. Consequently, this writ petition stands disposed of with a specific direction to the respondent Tahsildar, Shidlaghatta Taluk, to consider the representation given by the petitioner, issue notice to all concerned, thereafter pass necessary orders as expeditiously as possible, at any rate within a period of 2 months from the date of receipt of a copy of this order. Stop. Ordered accordingly.
Decision was taken by the land grant committee to grant the land in favor of the petitioner, issue the Sagodi check. Despite the same land, till today they are not issuing Sagodi check to give the petitioner. The D and E. They specifically says that she is entitled for the Sagodi check also. But they are corresponding. Tahsildar writing to State Commissioner and the State Commissioner DC. So they are corresponding instead of issue this Sagodi check. They have taken the decision.
The two petitioners are there. Both of them are given.
We are appealing for the. We are appealing for both the petitions.
Correct.
Yes.
Only one application or two applications?
Two applications.
Separate application. Earlier also you had approached this court. What is this? What is this annexure H?
Annexure H is the blood identical man where the Sagodi court has similarly situated person. To issue the Sagodi. Sagodi court has passed the order.
Why it was not considered?
Correspondence not there.
In that writ petition, there are 120 petitioners.
Yes.
So, if a general direction is given, how is it that only your application?
No general election.
Why not?
It
is a bit confined only to the petitioners, is it?
Yes, it is only.
Why? Why?
That was the case, that is not a general order to consider. If that is applicable, then we have to prevail at all. But it is not the case. So
it has to be, sir. Yeah, you are saying there is a direction issued to the Tahsildar to consider the applications.
in respect of those who approached this honorable.
They definitely, this court would not restrict the application only to the petitioners before the court. Under these circumstances.
We are prepared to produce the order and we make a request. We should not say that.
ಏನಾಗಿದೆ ಇದಾದ್ಮೇಲೆ?
ಅದಾದ್ಮೇಲೆ the national credit is similar. They are seeking the direction of the Ashika again right into the DC. ಕೊಡಬೇಕಾ ಬಿಡಬೇಕಾ ಅಂತ ಕೇಳ್ತಾರೆ.
ಅಲ್ಲ ಈ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ
ಈ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಇದು
what happened to those writ petitioners?
ಅವ್ರಿಗೆ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡೋದಕ್ಕೆ. I don't know what has happened. Whether they complained, time was also given for 4 weeks time was given.
Correct. That is why I am asking you what happened to those red petitioners.
Use this order to show that in the similar situation, not the sum of direct. Subsequently, we are not appearing that matter. They should subsequently. Time was also fixed.
ಇವೆಲ್ಲ ನೋಡ್ಕೊಂಡು ಬರ್ಬೇಕಪ್ಪ ನೀವು.
Time was given.
ಹಾ
That was the matter wherein the Tahsildar was part of the committee.
ಹಾ
He had given his assent for grant of land. Subsequently,
Tahsildar is always a part of that committee.
he is the secretary. This honorable court observed that having been part, he has given his assent. Subsequently, was not justified in refusing to issue the.
Correct.
document.
That is why I am asking you what happened to those red petitioners. ನೀವು ಅದನ್ನೆಲ್ಲ ಏನು ಕೇಳದೆ ತಿಳ್ಕೊಂಡೇನೆ you are coming as if your application is not considered. When 120 persons are before this court and this court directs the Tahsildar to consider all the applications. Please understand, if they don't consider other petitioner, other applications, there is always a danger of considering the application without considering the claim of another person. There may be claim in respect of the same land by 2 persons. So that is why they call for objections, go find out, make a spot inspection, verify what is the land which is in their occupation. ಈ ಎಕ್ಸೈಸ್ ಎಲ್ಲ ಮಾಡಿದಾಗ ನಿಮ್ಗೆ ಗೊತ್ತಾಗೋದಿಲ್ವಾ?
Number decision.
ಖಂಡಿತ ಗೊತ್ತಾಗುತ್ತೆ.
Decision ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. Only thing is to issue the salvation if they are not doing.
ಹಂಗ ಹೇಳ್ತಾ ಇದ್ದೀರಾ, but it is the same thing.
What mechanism like? They have taken a decision. They are issuing this. They are saying like whether to issue or not.
Now, if the applications of all those petitioners are considered and grant certificate are issued, then if you are laying claim in respect of the same property,
Not same problem.
you do not know.
Those petitions are different. This is the land from the article count.
ಅದರದ್ದೇ ತಾನೇ ಇದು
Party illa. Our petition of party illa.
ಅತ್ತೆ ಬೆಲೆ ಅದೇನೇ ಇದು.
Our party illa.
Correct, sir. You are not a party. I understood. ಆದ್ರೆ applications are filed by several persons. These are all huge Gomar lands, and they say we are in unauthorized occupation. The rule says that if there are rival claims, you will have to consider the application together and dispose of. Otherwise, ನೀವು ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಡಿಸ್ಪೋಸ್ ಆದ್ಮೇಲೆ ಇನ್ನೊಬ್ಬ ಬರ್ತಾನೆ, ಇಲ್ಲ ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ ಅದೇ ಜಾಗಕ್ಕೆ ನಂದು ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ ಅಂತ. Therefore, I asked you, when the entire exercise took place after directions were issued by this court, what were you doing at that point of time?
In our case, there is no rival claim at all. It's an independent claim.
ಇವಾಗ ಗೊತ್ತಾಗುತ್ತೆ, ಅಲ್ಲಿ ಇವ್ರಿಗೆ ಹೇಳಿ ಕಳ್ಸಿದ ಮೇಲೆ ಅವಾಗ ಗೊತ್ತಾಗುತ್ತೆ. That is what will happen. ಬರ್ಕೊಳ್ಳಿ. And AG takes notice for all the respondents. Next para. The senior counsel, Shri H. Kantaraja, appearing for the petitioners, draws the attention of this court to an order dated 2nd of August 2021, passed by a coordinate bench of this court in WP number 15077 of 2020. Stop. There were 120 writ petitioners in that petition, and their grievance was, like the petitioners, that though the Committee for Regularization of Unauthorized Occupation had passed orders recommending grant of land to the applicants who had filed applications in form number 50 for grant of lands, comma, by order dated 16/9/1994, comma, however, till date, Sagoli chits are not issued. So, considering the grievance of the petitioners, this court, the coordinate bench issued a writ of mandamus directing the respondent Tahsildar, Anekal Taluk, to consider the representation given by the petitioners for issuance of Sagoli chit in terms of the resolution said to have been passed by the committee. Learned Senior Counsel submits that the similar benefit is required to be given to the petitioners, comma, since the petitioners too had made an application in form number 50 way back in the year 1991, and in the recommendation, a resolution for order dated 16/9/1994, which was made by the committee, comma, the name of the petitioners are also found. Full stop. However, learned AGA points out to the order passed by the coordinate bench on 16/8/2021, which is an order for being spoken to. Full stop. It is found that although there was a direction issued by the coordinate bench that the Tahsildar is bound by the resolution of the committee for regularization of unauthorized occupation, comma, however, comma, it was left open to seek cancellation of the said grant or regularization in terms of Rule 108K at the hands of the Assistant Commissioner, comma, should there exist grounds therefore. Full stop. Next part. Having heard the learned senior counsel for the petitioners, comma, the learned AGA, and on perusing the petition papers, comma, this court finds that in terms of the orders passed by the coordinate bench in WP number 15077 of 2020 pertaining to the applications made by various other persons in respect of lands situated within Anekal Taluk.
Land AG and on perusing the petition papers, this court finds that in terms of the orders passed by the coordinate bench in Eviction is also pertaining to the applications made by the various other parties situated within
Taluk, comma, if the Tahsildar has proceeded to issue Sagoli chits for grant certificates to the grantees in terms of the resolution for order dated 16/9/1994 passed by the Committee for Regularization of Unauthorized Occupation, comma, then the petitioners too are entitled to have grant certificates issued in their favor. So, on the other hand, comma, if action is initiated by the Tahsildar or the Assistant Commissioner in terms of Rule 108K of the Karnataka land grant rules and the grants have been cancelled, then the same would become applicable to the petitioners also. Stop. Next para. Consequently, the writ petition stands disposed of with a direction to the fourth respondent Tahsildar Anekal Taluk. Consider the grievance of the petitioners in the matter of issuance of Sagvoli chits, consequent to the recommendation for order dated 16/9/1994, said to have been made by the committee. Stop. If Sagvoli chits are issued to other persons under the recommendation for order dated 16/9/1994, then the petitioners are also eligible for grant of Sagvoli chits. Stop. On the other hand, if action is taken under Rule 108K and any orders are passed, the same shall be informed to the petitioners. Full stop. At any rate, the entire exercise shall be completed as expeditiously as possible, and at any rate within a period of 2 months from the date of receipt of a copy of this order. Full stop. Ordered accordingly.
Starting the AB matter, 17 order.
Yes, sir. ಏನಂತ ಏನ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ? ಓಡಿ ದುರಸ್ತು ಆನ್ಲೈನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿಲ್ಲ. ಆನ್ಲೈನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ it will be considered within the time frame. We have passed several orders, same order will be passed. Yes, online OD and Duras.
Notices for annexure G. Here, the Tahsildar has issued a notice under section 39 of Karnataka the Land Revenue Act. Since the earlier occasion, the petitioner wife has challenged. Earlier occasion, the petitioner, the wife is the absolute owner of the suitful property. 5 acres 31 guntas. But where the Tahsildar issued a notice under section 192A of Karnataka Land Revenue Act, but by issuing a notice to the petitioner wife. But thereafter, the petitioner wife has challenged the petition before the sum court. The sum court has directed the Tahsildar that the opportunity has to be given to the petitioner by giving the objection as well as the documents. Thereafter, after hearing the petitioner by giving full opportunity, the order has to be passed in this regard. Lordship comments in page number 32 and 34. 32, paragraph number 3. On hearing the ground counsel for the petitioner and perusing the petition papers, this court finds that the improved notice call upon the petitioner to submit relevant documents to substantiate the title of the petitioner over the land in question. However, the Tahsildar is required to give sufficient time to the petitioner to substantiate his contention along with the relevant documents. The Tahsildar is required to afford an opportunity of hearing the petitioner and thereafter pass an order in accordance with law. Consequently, the petition stand disposed of with the direction to the second respondent Tahsildar to afford an opportunity of hearing the petitioner to substantiate his claims along with the relevant documents. The petitioner shall be heard.
Yes,
But now, the petitioner, the wife has been dead 1 month back. Now, on 23/8/2022, but now the notice has been issued under section 39 against the petitioner, the wife of the earlier petitioner.
What happened to the previous
No.
proceedings?
Please, madam.
What happened to the
No.
previous proceedings?
No such orders have been passed. I have been given the objection along with the documents. Without passing any orders as per the direction of this on court. Now issued under section 39, even murdered under section 39 as per the notice, but it is notice has to be issued murdered by the deputy commissioner, not by the Tahsil.
Please read the last two paragraphs in the notice. ಮುಂದುವರೆದು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಪ್ರಕರಣ ಸುವರ್ಣಸೋರಲ್ಲಿ ಅರ್ಜಿದಾರರಿಗೆ ಅದೇ
ಅರ್ಜಿದಾರರಿಗೆ ಸೂಕ್ತ ದಾಖಲೆಗಳಿಂದ ತಮ್ಮ ವಾದ ಸಮಸ್ಯೆ ಸಾಕಷ್ಟು ಸಮಯ ನೀಡಬೇಕಾಗುತ್ತದೆ ಹಾಗೂ ಅರ್ಜಿದಾರರಿಗೆ ವಿಚಾರಣೆ ಅವಕಾಶ ನೀಡಬೇಕಾಗುತ್ತದೆ ಮತ್ತು ನಂತರ ಕಾನೂನು ಪ್ರಕಾರ ಆದೇಶವನ್ನು ರವಾನಿಸಬೇಕೆಂದು ತಿಳಿಸಲಾಗುತ್ತದೆ. ಅದರಂತೆ ತಮಗೆ ಸಾಕಷ್ಟು ಕಾಲಾವಕಾಶ ಕೊಟ್ಟಿದ್ದು ತಾವು ಯಾವುದೇ ದಾಖಲೆ in the subsequent first paragraph, second paragraph, it has been referred. Adarante Dinaka, after passing of this petition earlier, on 12/1/2022, but I have given the documents as well as the objection to the.
ಹುಣಸೆಕಟ್ಟೆ ಗ್ರಾಮ ಸುವರ್ಣಸೋ ಎಕರೆ
ಜಮೀನು ಸಂಪೂರ್ಣ ಜಮೀನು ನಾವು ಸಾಗುವಳಿ ಮಾಡಿಕೊಂಡು ನಾವು ಜೀವನ ಸಾಗಿಸುತ್ತಿದ್ದೇವೆ ಹಾಗೂ ಈ ಖರಾಬ್ ಜಮೀನನ್ನು ಮಂಜೂರಾತಿ ಮಾಡಿ ಜೀವನ ಸಾಗಿಸಲು ಅನುಕೂಲ ಮಾಡಿಕೊಡಬೇಕೆಂದು ತಮ್ಮ ಲಿಖಿತ ಹೇಳಿಕೆಯಲ್ಲಿ ಪ್ರಸ್ತಾಪಿಸಲಾಗಿರುತ್ತದೆ. I have given the objection. On the opportunity has to be given to the petitioner. As of before the issue the notice to the husband of the petitioner.
Your wife had made an application seeking grant of that land.
No, grant of land. In fact, the wife is.
ಈ ಖರಾಬು ಜಮೀನನ್ನು ಮಂಜೂರಾತಿ ಮಾಡಿ ಜೀವನ ಸಾಗಿಸಲು ಅನುಕೂಲ ಮಾಡಬೇಕು.
But after passing of this petition, she has given the objection to the Tahsildar, saying that since I am in possession of the scheduled property of 5 acre 31 guntas, including the crab land of 2 acre 27 guntas, where the government the Katte is water source is existing on the crab land. Now she has seeking before the Tahsildar by filing of objection after passing of this some direction.
ಕೆರೆ ಹೆಂಗ್ ಗ್ರಾಂಟ್ ಮಾಡಕ್
This
ಬರುತ್ತೆ?
is not a kere
ಮತ್ತೆ
this is a the water source within the within the scheduled property of the petitioner. But the water source is only for the cultivation of the land of the petitioner, not by the others. Now the section 39 has been issued without passing the orders.
From where do you get all these things that it was attached only to your land? Only you have right in the respect of that.
That is why the direction of this court has to pass an order whether the petitioner is the owner of the property, whether she have right to use the 2 acre 27 gunta existing in the Karab land, whether the petitioner is having the right to enjoy and use the same or not. But unless the order shows
What is the document that you have produced to show that you are the owner of the land and you are not asking for any grant for them from them? Please show document.
in page number 16, annexure B.
16.
This
RTC.
is the RTC. But where the survey number 1.
Where is the document of title?
This is the Karab land existing in the
See,
Karab
when I
land.
asked you whether your wife was asking for a grant, you said, no, it belongs to me. I am asking you, what is the title? Please show.
Since the petitioner has not sought for the grant of this
Aito, accepted.
Only
Accepted that you are not asking for a grant. You say it is your own land. I am asking you, what is the document to show that you are the owner of this land?
But please show. I am the owner of the property.
Yes.
With respect to the survey number.
How, sir? How?
But 5 acre 31 guntas. Number 16. 5 acre 31 guntas. But total acre of the land is 8 acres 18 guntas.
Yes.
Including 2 acre 27 guntas is the Karab land. But my land is the 5 acre 31 guntas.
Yes.
But since the 2 acre 27 gunta is a Karab land, where the water source is for the cultivation of the land of the petitioner is using. But no other the villagers are using the land water source.
How can you say that, sir? How can you say that? It is clear even from the RTC that you are not the owner of that land. You are owner of 5 acres and 31 guntas of land.
Kindly see, annexure E.
B Karaval Torsada.
Earlier, my lords,
B Karab, it cannot be alienated.
earlier reason my lords have interfered because 192A criminal proceedings they entered without providing an inquiry. Earlier,
No, my
Kumar
lord,
said,
section
but
39.
now 39 is a proceedings.
Only, my lord,
He is a delegate, he is having a power.
Section 39, my lord, of the Karnataka Land Revenue
Commissioner has
Act
a power.
contemplated only an issue of notice by the Dashildar. Now, by the deputy commissioner, not by the
ಇನ್ನು ಏನು
Dashildar.
ಆದೇಶ ಮಾಡಲಿಲ್ಲ.
But there is a contemplation procedure. Only, my lord, the deputy commissioner has to issue a notice for eviction of, my lord, the possession, for eviction of any person who is in unauthorized possession. Only, my lord, after passing of an order by the deputy commissioner, but considering that, my lord, whether, my lord, the person is in unlawful possession or whether the property belongs to the government or whether he is in possession of the property and unauthorized, then only, my lord, the deputy commissioner has to issue notice under section 39 of thereupon, my lord, if, my lord, the person even after passing issuing a notice to the deputy commissioner, if he is, my lord, is objecting or if he is not evicting from the property which is an unauthorized possession, thereafter, my lord, the Dashildar has been given a power to make a preliminary inquiry whether why the person is not in, my lord, evicting the in the unauthorized possession. Only, my lord, the deputy commissioner is having a power to issue a notice under section 39, not by the Dashildar.
But it's Roman 1. This is issue. Here, my lords. Is it?
Huh?
9. Latest my lords have contemplated that the deputy commissioner may have power is now, my lords, delegated to Dashildar. Inquiry they are giving. And inquiry notice now, which is given here. 2 acre 27 guntas, which is admittedly big Kharab land. Public property, so he cannot have any grievance and cannot have any title. First occasion, my lords interfered only because it is 192A proceedings, initiation of criminal proceedings. Without inquiry, my lords, they have stayed like us. My lords, they may proceed, they may not proceed. It's not that he cannot insist that 192 proceedings is
Circular delegating this power to the Dashildar.
place that. Because all 139 years, all these matters now, Dashildars are being excised. And that is that. Is that all 139 years inquiry is conducted by Dashildars only? They are issuing the notice, they are the authorities.
You have given
It
opportunity.
is no, let him pass, my lords, if it is passed also, it will be without jurisdiction, but he cannot come at the stage of notice only. It clearly shows that, my lords, his attempt is to squat out the Kharab land.
We have also discussed many times.
Yes,
In terms of section 67,
yes.
it is only the deputy commissioner who is entitled to. How so? Stand, but everything comes under 67. There cannot be a parallel powers granted to the Tahsildar.
No, my lords, it is not section.
Please see section 67.
Yes, 67, my lords, can kindly see. This, my lords, section 67 gives a declaration that these are the public properties.
No,
which is
no,
not-
no. Any of these things, there is encroachment on any of these properties. It is only the deputy commissioner who is empowered to pass orders, and the orders of the deputy commissioner is not final. The aggrieved person should go to the civil court. That power cannot be delegated to the Tahsildar.
In respect of these classifications only.
ಅದೇ ಇದೆ ನೋಡಿ ಅಲ್ಲಿ.
My lords, that does not mean that.
ಬೆಡ್ ಎಲ್ಲ ಇದೆ ಅಲ್ಲಿ.
ಅಲ್ಲ, ಅದಿದೆ. But section 39 also, my lords, may I request my lords to kindly.
That's what. If the state government has issued such a circular, it will be directly in the teeth of section 67, which powers could not be delegated to the Tahsildar.
It is not, even under 104 also, my lords.
104, now we have discussed, it is only where there is violation of any conditions attached to the tenure. ಅದನ್ನ ಯಾರು ನೋಡ್ತಾನೆ ಇಲ್ಲ.
39 ದಲ್ಲಿ power is there, my lords.
There
Nobody
is
challenged that.
there is lot of wisdom. If a particular action is power is conferred on a particular authority, higher authority, in respect of certain actions, and the appellate authority or the appellate powers is conferred on a civil court, would that power be delegated to the Tahsildar? Public roads, so nodi, if there is a encroachment on public roads, which is used by the general public.
Let's kindly see the classification.
Yes, yes.
All public roads,
Yes.
streets, lanes, paths, bridges, ditches,
Dikes.
dikes, fence.
Hmm.
Besides the same, the bed of the sea or harbors, creeks below the high water marks, and rivers, streams, nala, lakes and tanks,
Hmm.
all canals, water courses, and all standing and flowing water, all the lands which whatever are situated, which are not the property of the individual or accrued person legally capable of holding the property, except in so far as any right of such person may be established or in for the same, or except may be otherwise provided in any law for the time being in force, are hereby declared, and all the rights for the same are appended thereto are the properties of the state. Well, subsection 1 says that these are the categories or whatever classification may be.
Correct.
Person who does not claim, it is a property of the state.
Correct.
Subsection explanation. High water mark, that
I
agree.
Ah.
Subsection. Where any property or any right in or over the property is claimed by or on behalf of the state government or by any person as against the state government, it shall be lawful for the deputy commissioner or the survey officer, not the below rank of deputy commissioner, or after formal inquiry, pass an order deciding the claim. Here, subsection 2 confers the power on the deputy commissioner or any survey officer, not below the rank of DC, to adjudicate a claim of a person who comes and says that it is property belong to me,
Yes.
which is the property actually belongs to the state.
Yes.
Then the DC at the
Hold a formal inquiry.
formal inquiry and pass out.
Yes.
Subsection 3 says that against that civil suit.
Yes.
But my lord, section 39 is a wider power conferred on the deputy commissioner,
Hmm.
not only these classes of land,
Hmm.
any other my lord's classification of land which is not
Wherever it is provided
by this act, wherever it is provided by this act or any other law for the time being in force, that the deputy commissioner may or shall evict any person wrongfully in possession of the land, where any order to deliver the possession of the land has been passed against any person under this act, such eviction shall be made or such order shall be executed as the case may be in the following manner. The manner of my lords, how it has to be done.
Therefore, it's the question of executing the orders passed.
It's not only that,
If
my lords.
the deputy commissioner has passed an order and that is not challenged, probably the circular says, yes, we will delegate the power of execution to the Tahsildar. Maybe. But there cannot be conferment of the same powers on two officers.
That is different situations, my lords. Hence, my lords,
We are concerned with a tank bed area.
lords, even if this general power is there. It's not that, my lords, only section 67 itself and other powers, other than my lords, lawmakers.
39 is more in the nature of executing an order passed already. Otherwise, ಏನಾಗುತ್ತೆ ನೀವು 2-3 ಕಡೆ ಇದೇ ತರದ ಪವರ್ಸ್ conferring on several authorities.
My lords, it's not only, there's two parts here. There's once again,
39, 67, 104. There are so many such provisions. And I'm sure you'll agree with me that the same type of powers will not be conferred on 2-3 authorities.
yes. Lords, under this chapter 3 of the act, the code, this revenue code, my lords, this is procedure of the revenue officer, chapter 3. Here, my lord specifically says that how he has to conduct inquiry in section 39. These are the general powers. My lords, but kindly see the chapter itself, heading of the chapter. Procedure of the revenue officers. Section 24, revenue officer and revenue code. What exactly? 25 is inherent power. Even Miller's, who it does not mention whether it's
Procedure of revenue officer.
yes. Here 25 is akin to Miller's 151. It is inherent power of the revenue officer. If statute does not say also we have power, it is not that Miller's jurisdiction on the ground of jurisdiction we cannot be ousted. Power trust. Then Miller's will kindly see these are the power in general in nature. By close reading of section
When there is a specific provision
that is
conferring a particular power on a particular officer, can it be delegated?
because that there is no challenge to that. Miller's, I'll examine that and come backwards. But there is no challenge to that. Miller's confirmation Miller's jurisdiction is not challenged. But he cannot be Miller's. It's admittedly that a person who is in a Arab land comes and Miller's obstruct the authorities.
The claim is that it belongs to me.
Allah, I think B Kharabat he admits all the artists clearly says that it is A Kharabat. I would not talk.
Now the question is whether the Tahsildar who has issued this notice.
Miller's I said. Grant me 1 week's time. I'll place.
Berkeley.
Inquiry cannot be hard pass. Thereafter it will come. Otherwise, inquiry cannot. Otherwise, every stage they will come and stop the revenue authorities process.
Now, why is it that the deputy commissioner is not acting under section 67 when there is a specific power granted only to the deputy commissioner?
I'll make my submission. Whether 67 overrides plus independent power. Inquiry go on.
Learned AGA takes notice for both the respondent. Learned counsel for the petitioner is directed to serve a copy of the petition on the learned AGA. Full stop. Next para. Learned counsel for the petitioner submits that on an earlier occasion, the petitioner's wife, Srimati Vedavati, was before this court in WP number 1045 of 2022. Challenging a show cause notice dated 1/1/2022 by the Tahsildar, Shikaripura Taluk, under section 192 capital A of the Karnataka Land Revenue Act of 1964. Stop. This court directed that the Tahsildar is required to give sufficient time to the petitioner to substantiate his contention along with relevant documents. Stop. The petition was disposed of by order dated 20th of January 2022, directing the Tahsildar to afford an opportunity of hearing to the petitioner to substantiate his contention along with relevant documents. So, learned counsel for the petitioner submits that in terms of the directions given by this court in WP number so and so, the petitioner's wife appeared before the Tahsildar and submitted relevant documents to substantiate her contention that she is the owner of 5 acres
31 guntas.
and 31 guntas of land in survey number 110/1H of Hunse Koppa village, Anjanapura Hubli, Shikaripura Taluk, to which 2 acres and 27 guntas of land, 27 guntas of Kharab land is attached. Stop. It is the contention of the petitioner that they said 2 acres and 27 guntas of Kharab land. It is attached to the land belonging to the petitioner, and the petitioner alone has a right to make use of that property. Full stop. Nevertheless, the petitioner's wife passed away Yavaga
24/7/2022.
on 24/7/2022, and the impugned order, impugned notice has been issued by the Tahsildar, this time invoking section 39 of the Act. Stop. Grounds raise ಮಾಡಿದಿರೇನ್ರಿ ನೀವು that Tahsildar is not competent. No power under section 39.
22 paragraph. Action of the second respondent who has no power under section 39 of the LR Act to issue eviction notice on such
Yes.
grounds acceptable by the deputy commissioner.
Yes, all right. Learned counsel has also pointed out the grounds raised in the writ petition, wherein the powers of the respondent Tahsildar to issue a notice under section 39 has been questioned. Stop. Learned counsel submits that it is only the deputy commissioner who is authorized and empowered to issue a notice calling for an inquiry in the matters of eviction of a land said to be a tank bed, in terms of section 67 of the Act, and section 39. Stop. Next paragraph. Consequently, there shall be an ad interim order of stay of all further proceedings pursuant to the impugned notice dated 23/8/2022 at annexure G, till the next date of hearing. Statement of objections may be filed in a period of 2 weeks.
Issues already changed. What if the method is unauthorized cultivate the land mineral? Thereafter, I file application before the annexed same. After the land committee is forward mineral, the demand notice was issued to pay the TT of the mineral. Already paid in the 2018. But till now, the Shalpuri TT are not issued. Necessary for application appointment was. Necessary is page number 12 mineral. Demand notice was issued. To produce Jamin on the Supreme Court was available tribunal of Tilman.
Learned AG takes notice for all the respondents. Next para. Learned counsel for the petitioner submits that improve separate grant,
Submit.
that the petitioners
Number 73 and
who had made applications in the year 1998 seeking regularization of unauthorized occupation of 2 acres of land in survey number 73 and 1 acre 20 guntas of land in survey number 72 were granted lands in terms of the recommendation bar order passed by the committee on 23/2/2018. Stop. Thereafter, notice were issued to the petitioner, as could be seen from annexure C and D, calling upon the petitioners to pay the premium for TT fine for Kimmat in terms of the orders passed by the committee. Stop. The petitioners paid the Kimmat as demanded by the Tahsildar. And the bank vouchers for receipt are found at annexures E, F, and F. Stop. Learned Council submits that although the Kimat demanded by the Tahsildar was paid on 1/3/2018 by both the petitioners, nevertheless, till date, Sagoli chits are not issued. Stop. Espera. The prayer in the petition is to direct the respondent authorities to issue Sagoli chit. The, ಅಲ್ಲ ಪೇಮೆಂಟ್ ಎಲ್ಲ ತಗೊಂಡ್ಬಿಟ್ಟಿದಾರಲ್ಲ ಆಗ್ಲೇ 2018 ಅಲ್ಲಿ. ಆಯ್ತು, we will direct them to treat this writ petition itself as the representative.
Prayer in the petition is to direct the respondent authorities to issue Sagoli chit
to the petitioners in terms of the grant orders. Espera. Having heard the learned counsel for the petitioners and on perusing the petition papers, this court finds that there are sufficient material available to support the contention of the petitioners. So, the Tahsildar, the respondent Tahsildar, was required to consider the grievance of the petitioners in the matter of issuance of Sagoli chits. Stop. Next para. Consequently, the writ petition stands disposed of with a specific direction to the third respondent Tahsildar, Arkalgudu Taluk, to consider the memorandum of this writ petition as a representation given by the petitioners for issuance of Sagoli chits. Full stop. The Tahsildar shall verify from the original records as to whether a grant was indeed made in favor of the petitioners and whether the Kimat was demanded and paid by the petitioners. Full stop. If the Tahsildar is satisfied that the grants were indeed made in favor of petitioners and the petitioners have already paid the Kimat demanded in accordance with law, then the Tahsildar shall proceed to issue the Sagoli chits as expeditiously as possible and at any rate within a period of 2 months from the date of receipt of a copy of this order. Full stop. Next para. On the other hand, if it is found that no such grant orders are passed by the committee, then the Tahsildar shall verify the orders, original grant register for orders passed by the committee in the presence of the petitioners and thereafter issue an endorsement according. Full stop. Ordered according.
Hmm.
96. Then petition number 2 is the party. Here, what is your contention?
Petitioner, my lord, is Srimati Saraswatama.
Ah.
Second petitioner is permanent.
Ah.
First petitioner's father. Second petitioner, father-in-law. Therefore, the property is 62 under a partition, registered partition deed. My father gets 95 but 2D.
So it's under a partition deed.
Partition. It is not even the same. What happens is, my father's brother gets 95 but 2A. He sells it to his daughter-in-law. This state is mentioned as 95 but 2D. What is not correct is document. They get an MR done by consent, thereby revenue is computed in respect to opposite. In fact, the father's property 95 but 2A, I go to 95 but 2D. But in fact, 95 but 2D, they are constructed a house. Because they get 95 but 2D, as well as they get no mind. They are not done usually, they have got a mark and as per the
Hello, that's all right. See, at any rate, the initiation of proceedings under 79 AB. Anupama Reddy purchased from Rama Reddy, her father-in-law. Here it is shown as 95 bar 2D. Barkal. AGA, HCGP takes notice for both the respondents. Correct. Only 6 guntas. The dispute is only regarding 6 guntas. Huh? In this writ petition, the petitioners seek to raise a challenge to an order dated 8/6/1996, passed by the Assistant Commissioner, Bangalore South Subdivision, invoking powers conferred under Section 83 of the Karnataka Land Reforms Act, 1961, for violation of the provisions contained in sections 79A and B of the Act. Full stop. As per learned counsel for the petitioners submits that the second petitioner herein, namely Srimati S. Anupama Reddy, purchased 6 guntas of land out of 11 guntas in survey number 95/2D of ಕೋನಪ್ಪನ ಅಗ್ರಹಾರ, ಬೇಗೂರು ಹೋಬಳಿ, ಬ್ಯಾಂಗ್ಳೂರ್ ಸೌತ್ ತಾಲೂಕು, under a sale deed dated 1/2/1996, which was executed by her father-in-law, Shri T. Ramareddy. ಇಲ್ಲಿ ಬರೀ ಟಿ ಅಂತಿದೆ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ. ಟಿ ರಾಮರೆಡ್ಡಿ. ಸ್ಟಾಪ್. ಶ್ರೀ ಟಿ ರಾಮರೆಡ್ಡಿ ಪಿ ವಿ ಗೋಪಾಲ್ ರೆಡ್ಡಿ, ಬಸವರೆಡ್ಡಿ, ಶ್ರೀ ರಾಮರೆಡ್ಡಿ and Shri Basavareddy, the father of the first petitioner herein, are brothers. Stop. It is submitted that what was actually transacted under the sale deed is 6 quintas of land in survey number 95/2A and not a 2D. Full stop. Nevertheless, after the sale deed was executed, the parties appeared before the Tahsildar and by consent, the name of Srimati S. Anupama Reddy was mutated and entered in survey number 95/2A and 6 quintas of land were mutated in the name of the first petitioner herein, namely Srimati Saraswatamma. Stop. Then a council submits that the petitioners are in peaceful possession of their respective lands and they have put up constructions of a residential building, since the lands were only 6 quintas each and they had lost the characteristics of an agricultural land. Stop. However, the petitioners have recently come to know of the said order passed by the of the impugned order dated 8/6/1996, said to have been passed by 8/6/1998, passed by the assistant commissioner for competent authority. Holding that the purchaser was not an agriculturist and she could not have purchased the agricultural land. Council submits that second petitioner did not receive the notice and the impugned order has been passed, placing the second petitioner ex parte. Stop. ಇದೆಲ್ಲ ಅದೇ ತರ ಮಾಡ್ಬೋದು. ಎಲ್ಲಿ? That's all right. I have correctly stated, isn't it? Yeah. Early disposal of it's 19/7/2021. Notice was ordered, is it? Huh? ಯಾವತ್ತು? ಡಿಸ್ಪೋಸ್ ಮಾಡಬಹುದು. ನಾಟ್ ನೋ. ಮತ್ತೆ ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡ್ಬೇಕಲ್ಲ, ಮತ್ತೆ ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? AGA takes notice for response number 1 and 2. Notice to respond number 3 and 4. Not necessary for the following reason. The prayer made in this writ petition is to direct the respondent, Assistant Commissioner, Tumkur Subdivision, to dispose of the appeal filed by the petitioner in RA number exactly KUN close 497 of 2021-22. In an expeditious manner. Stop. Learned Counsel submits that the petitioner filed the appeal on 19/7/2021, and till date the contesting respondent has not filed objections. Respondents have not filed objections, and the matter is not being heard and concluded. Therefore, the instant writ petition is filed seeking directions. Full stop. Next para. Having regard to the innocuous prayer made by the petitioner, this court is of the considered opinion that no harm or prejudice will be caused to the contesting respondents if a direction is issued to the Assistant Commissioner to dispose of the appeal within a time frame. Stop. Next para. Consequently, the writ petition stands disposed of with the direction to the respondent, Assistant Commissioner, Tumkur Subdivision, to conclude the proceedings in RA number so and so as expeditiously as possible and at any rate within a period of 6 months from the date of receipt of a copy of this order. Stop. Ordered accordingly. amendment. Finally, 2 weeks are granted at the request of the learned counsel for the review petitioner to carry out the amendment postulated.
My lord, I am appearing for review petitioners. I seek short accommodation, my lord. I am appearing for review petitioners. A
Short accommodation.
short accommodation may be.
For what, sir?
The petitioners intend to engage the senior counsel, my lord.
Huh?
Petitioners intend to engage the senior counsel, my lord. Short accommodation may kindly be granted, my lord.
At the request of learned counsel for the review petitioner. Matter after Dasara vacation.
Obliged, my lord.
Learned counsel for the petitioners and the petitioners have filed a memo dated 22/9/2022 stating that are seeking leave of this court to withdraw the writ petition as not pressed. Stop. Next para. The memo is taken on record subject to all just exceptions. Accordingly, the writ petition stands dismissed as withdrawn. ಏನಾ ಏನಕ್ಕೆ ಏನಾಯ್ತಪ್ಪ
Was directed to produce the document. As per my instructions, Tahsildar and VDLR is present. They say that only not been conducted because we do not have any records or documents. ಮಾಡಬೇಕಾಗುತ್ತೆ. This is on that only annexure N was issued to the petitioner. The challenge. ಲಭ್ಯವು ಇರುವುದಿಲ್ಲ ಅಂತ ಹೇಳಿ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. They had applied for Kodi Durasti certified copy.
See, their contention is that the petitioner purchased this land under a registered sale deed dated 28/11/2007. Then they applied for conversion. During the time of conversion, all these activities have taken place. And now how can you say when the order of conversion, adene at the time of conversion, in the year 2012 ಅಲ್ಲಿ ಕನ್ವರ್ಷನ್ ಆಗಿದೆ ಈ ಲ್ಯಾಂಡ್. has it been converted? ಆ ಟೈಮ್ ಅಲ್ಲಿ at the time of ordering conversion they had not directed for conducting the survey and other things. ಅವರು ಅದನ್ನೇ ಕೇಳ್ತಾ ಇರೋದು.
Two thousand five.
2005. You purchased converted land. ಏನ್ರಿ ಹಿಂಗ್ ಹೇಳ್ತೀರಾ?
At the time of conversion, ದುರಸ್ತಿ ಮಾಡಿ ಕೊಡುದು ಇರ್ಲಿಲ್ಲ. Actually, they say that they had made an application for a certified copy to us for Kudi Durasti ಇದನ್ನ ಕೊಡಿ ಅಂತ ಹೇಳಿ certified copy ಕೊಡಿ ಅಂತ ಹಾಕಿದ್ರು. For that we issued an endorsement as per annexure N, saying that ನಮ್ಮ ಹತ್ರ ಲಭ್ಯವಿಲ್ಲ ಈ ದಾಖಲೆ ಅಂತ endorsement ಹಾಕಿಕೊಟ್ಟಿದ್ವಿ. Now subsequently this honorable court's order we have verified for ADLR and Tahsildar. They say that documents are not available.
When was this land converted?
2005.
2005. At the time of conversion, how was that order of conversion passed by the deputy commissioner without securing report from the Tahsildar? $2002. ಆಯ್ತು. ಕನ್ವರ್ಷನ್ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡುವಾಗ ದಿ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ವುಡ್ ಹ್ಯಾವ್ ಸೆಕ್ಯೂರ್ಡ್ ಆಲ್ ದಿ ರಿಕ್ವೈರ್ಡ್ ರಿಪೋರ್ಟ್ಸ್ ಫ್ರಮ್ ದಿ ತಹಸೀಲ್ದಾರ್ ಅಲ್ವಾ? ವಾಟ್ ಆರ್ ದಿ ರಿಪೋರ್ಟ್ಸ್ ಆಫ್ ದಿ ತಹಸೀಲ್ದಾರ್ ದಟ್ ಹ್ಯಾಸ್ ಬೀನ್ ವೆರಿಫೈಡ್? Ivaga, what is the contention of this Tahsildar now?
They say that presently the record, they do not have any records pertaining to the said.
How can it be when an order of conversion is passed by the deputy commissioner? How can they say that there is no records available?
ಲಭ್ಯವಿಲ್ಲ.
Listing record ಯಾಕೆ ಬರುತ್ತೆ ಈಗ? How did the deputy commissioner pass a conversion order under section 95 then? Huh? Without verifying any records, the deputy commissioner has passed an order of conversion, is it?
ಕನ್ವರ್ಷನ್ ಕೂಡಿ ಆಗ್ದಿರಾನೆ ಮುಂಚೆ ಮಾಡಬಹುದಾಗಿತ್ತು. 2002 ಅಲ್ಲಿ ಕನ್ವರ್ಷನ್ ಕೂಡಿ ಆಗ್ದಿರಾನೆ ಕನ್ವರ್ಷನ್ ಮಾಡಬಹುದಾಗಿತ್ತು.
ಸರಿ ಆಯ್ತು. Whatever it is, an order of conversion has been passed by the deputy commissioner in year 2002. What are the records looked into at that point of time? You again, what exactly is your grievance now? For what? For what purpose are you requiring the document now? After if it is a land, converted land, for what purpose are you asking this document?
Time of conversion, they would have verified RTC, MR, and an endorsement saying that it doesn't come under 79A.
Sorry.
ನೋಡಿ ಅವತ್ತಿಗೆ conversion order ಆಗಿದೆ. Subsequently, come before this court, ಇದು ಕೂಡಿ ದುರಸ್ತಿ ಆಗಿದೆ, ಅದ್ರ ಕಾಪಿ ನಮ್ಗೆ ಕೊಡಿ ಅಂತ ಹೇಳಿ ಬಂದಿದ್ದಾರೆ. They had applied for a certificate copy.
No, what exactly is your grievance? We are not able to understand. Okay. In terms of the directions issued on 29/2022, the learned HCDP yaru Tahsildara has kept the Tahsildar and ADLR present before this court along with the records. Stop.
want a certified copy of Kudi and Durasti done by the authority. ಅದನ್ನ ನಮಗೊಂದು ಕಾಪಿ ಕೊಡಿ ಅಂತ ಬಂದು.
Sir, what is your grievance? What is it that you want?
I want the results. I want the copies.
Which tippany, which copy?
That very is 172. There were earlier issues. And now they are saying it is an extension. It is an extension. All these documents are earlier issued. They for
What exactly, why what is the reason behind you asking for these documents once again? There should be some reason. Tell me what is the reason?
The way those documents are being, there is not being displayed that you endorsement. And then what when I asked
For what purpose are you requiring the
my
document?
document updated, the portion of my answer converted. And keep my
You
document.
purchased converted land.
No, I purchased the agriculture land.
Sir, in the year 2002, there is an order of conversion passed by the deputy commissioner. When did you purchase the land?
Plus, I purchased in the year, my vendor had purchased this land in the year 19.
When did you purchase the land, sir?
I purchased in the year 2007. Not all this land was converted.
Ah.
Land and survey were open. Portion of it is converted. Portion of it is not converted. So this is the land of land. Therefore, I want. When I said that you were doing this that I want this document because there are mistakes of the document for the area and many documents are being discussed and some land has been going on rampant way because of this land survey of 47. Various land certificates have been created. There are cases, multiple cases are there over there.
ಈ ರೆಕಾರ್ಡ್ಸ್ ನಿಮ್ಮ ಇದರಲ್ಲಿ ಒರಿಜಿನಲ್ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಇದೆಯಾ ಇಲ್ವಾ?
ಆರ್ಟಿಸ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಆರ್ಟಿಸ್ಟ್ ಇವತ್ತು ಬರ್ತಾ ಇದೆ ಸ್ಟೇಟ್ ಸರ್ವೆ ಪ್ರೊಡ್ಯೂಸರ್ಸ್ ಆರ್ಟಿಸ್ಟ್ ಈ ಸರ್ವೇಸ್ ಆರ್ ಕಂಡಕ್ಟೆಡ್ ನಾಟ್ ಇನ್ ಇಂಡಿಪೆಂಡೆಂಟ್ ಡೆವಲಪ್ಮೆಂಟ್ but then the order of the sovereign.
Which is the sale deed under which you purchased the land?
Purchased the land and the sale deed at next year 2011-2007 various effect of land development. I have purchased as 47/310, 47/313, 47 part 3 acres of land, or 47/314, and 47/315, and 47/317. So they are numbered as 132 to 132.
Converted lands. You purchased converted land.
I purchased converted lands to existing road. Certain lands are even existing land between them. Between them there are converted lands. I purchased only these lands. 47/310, 47/313, 47/314. And now they are renumbered as 172, 172.
All these scheduled lands are converted lands.
All these lands were converted lands. Which means that the survey number 47 and 47. Or the larger extent of land, 88 acres and 58 acres. And my land going away even, the remaining land remains for the purpose of nature of process for purpose of the land. And therefore I said these people were coded, these lands were coded and different numbers have been given. 178, 174. I produced this document and it's Gmail ID. And the RTPs were reflected over there. RTPs have been affected to all this land. Subsequently, on conversion, The converted land required to be taken away, and land accessible to the tax required to be left over there.
Where is your unconverted land?
But in 173, my lord, I purchased 1 acre of land.
Where is
There
the
is
sale
no-
date?
No, this is the, I have purchased this land, and I required to do the land, sale deed to my vendor. Then we each and every seven of them different.
We are not concerned with your vendor, sir. I asked you a question. What you purchased under the sale deed? You have shown me the sale deed.
Yes, sir.
All the 4 properties are converted lands.
Yes, sir.
Where is your unconverted land?
Lord, sir,
Under which sale deed have you purchased?
Lord, sir, under this said, the deputies, under this 2007 said edition, have purchased various lands. Which are converted over here. The remainder of the lands available in page number 63.
How are you concerned with that, sir? How are you concerned with that?
But I'm proud of this, my lord, mine is unconverted, undeveloped land. Now they don't have the municipal record because it is undeveloped land.
Ah.
And unless it is being bifurcated into a different survey number,
Hmm.
the larger extent of the land is not include even this. This is the problem. Where exactly that I am seeking to show, the only document is looking at first.
So you are unable to identify your lands.
No, I am able to identify that.
Huh?
When lands are identified and picnic has been given, and now they are saying those copies are not available. It's not that I am not aware, my lords have produced the copies of the copies issued by them, various surveys that is conducted by Director E to Director J. They have conducted this survey, they bifurcated these lands.
ಕುಂದಾನ ಹೋಗ್ಲಿ 5 ತೊರೆ
ಇಲ್ಲ.
ಕುಂದಾನ ಹೋಗ್ಲಿ ದೇವನಹಳ್ಳಿ.
ಸರ್ವೆ ಮಾಡಿದ್ದಾರೆ, ಸರ್ವೆ ಮಾಡಿ ವೆಬ್ಸೈಟ್ 47 ನಲ್ಲಿ ರಿಸ್ಟ್ರಿಕ್ಟೆಡ್ ಲ್ಯಾಂಡ್ ಎಂದು ಮಾಡಿದ್ದಾರೆ.
Earlier also you were before this court.
I was before this honorable court was earlier, and this honorable court had directed for survey. Subsequent to the order of honorable court, survey was conducted. And this survey conduct ಮಾಡಿ document ಎಲ್ಲ create ಮಾಡೋದು. ಮಾಡಿದ್ಮೇಲೆ ಈ 35 ಕಾಪಿ ಕೊಟ್ಟು ಈ ಕೇಳಿದ್ರೆ ಸರ್ ಕಾಪಿ ಇಲ್ಲ.
I can't understand, sir. Having obtained an order at the hands of this court, you say survey was conducted.
Survey was conducted. 35 copies were issued. I produced those 35 copies and annexed GTE.
GTE.
Make it easy. Annexed E in the start ಆಗಿತ್ತು. Annexed E survey ಮಾಡಿದ್ದಾರೆ, survey ಕಾಪಿ ಅಂತ ಮುಂದೆ produce ಮಾಡಿದ್ದಾರೆ. 47 ಅಲ್ಲಿ extended time ಇದೆ ನಮ್ಮ ಕೋರ್ಟ್ ಪ್ರದೇಶ ಅಂತ ಮಾರ್ಕ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ. Annexed E 43 ಇಂದ ಶುರು ಆಗುತ್ತೆ.
This was issued in the year 2013.
Subsequent to the order of honorable.
Why are you asking again?
I want that my these documents are not available on the problem.
How are you, sir?
Further
You
coding
say these are documents given to you after survey was conducted in terms of the directions issued by this court. Why are you asking for these documents?
further indexation with respect to the village map has not happened.
So what?
But
These are all converted lands, sir. Please understand, the moment the land is converted, alienated, it is called alienated in terms of the provisions of the act. Only for a limited purpose, the records are maintained.
to show where exactly the possession of the property, identity of the.
There are two things. One is regarding the maintenance of the record of rights. Other thing is maintenance of records of the survey.
To show the identity of the land.
Tippani, Akarband.
To show the identity of the land.
Yes.
To show the identity of the land.
Yes.
And what these documents have been given to me, now there are land grabbing in this and out that area. There are enforcement of portion of my land even. That's why I applied the technique of for the purpose of upgradation of my document. That I stated.
How can they say that we have not issued this document when there is a specific direction given by this court in the earlier petitions, directing them to conduct the survey?
Survey was conducted subsequent thereto only. Order of this honorable court. Tipri and class and Atlas are maintained only for Akarband is a different. Because for Tipri and Atlas, they are maintained for purpose of identity of the land.
The original grant record is not there.
We are not concerned with all that. I am fed up with this kind of answer being given by the Tahsildar and the ADLR. We are not concerned with whether there was a original grant or not. How are they concerned with whether the original grant was there or not?
Earlier petition was contested petition, was contested.
Have they not conducted the survey in terms of the two orders passed by this court?
They say the survey was conducted, but countersign was not done. So they do not have the record of this in the ADLR. ಆಗ ಮಾಡಿರೋದು ಸರ್ವೆ ಮಾಡಿರೋದು ಕೌಂಟರ್ಸೈನ್ ಹೋಗಿದೆ, ತಹಸೀಲ್ದಾರ್ ಆಗಿಲ್ಲ. ಸೊ ಇವ್ರ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲ, ಅದು ಎಂಟ್ರಿನೇ ಆಗಿಲ್ಲ. What they have produced, this document is not there in their entry.
Which is the order of conversion? Please show. 2002. Which is the order of conversion? What is the extent of land converted?
So 2/4, it's 78 to 80. Say 89 and all.
What is the extent converted? 3 acres.
3 acres converted in there are various certificates. ಒಂದೊಂದು ಎಕರೆ ಅಗಲದ ಕ್ವಾಂಟಿಟಿ
ಟೋಟಲಿ ನಿಮ್ಮ ಹತ್ರ ಎಷ್ಟು ಕನ್ವರ್ಷನ್ ಆರ್ಡರ್ಗಳಿದಾವೆ? There are 6 conversion orders.
ಆಮೇಲೆ ನಾನು ಒಂದ್ ಸೇರಿ ಪರ್ಚೇಸ್ ಮಾಡ್ತೀನಿ. The remainder required to be allocated to go. Where exactly my land, whether exactly the land is affected.
So if the deputy commissioner has passed 6 orders of conversion and the total extent of land converted is
12 acres of land.
12 acres of land, your property falls within that 12 acres.
Yes, property is 12 acres of land.
The entire 12 acres, 12 acres you have purchased.
Yes, I have purchased. Under the resolution, I have purchased around 43 acres of land, including various other land. But in this particular, the 12 acres.
So they are now asking that in terms of the original conversion order passed by the deputy commissioner in the year 2002, 6 conversion orders are here. Let them identify the land that were converted, permitted to be converted. I am sure there has to be records to show which were the 6 pieces of land that were converted at the hands of the deputy commissioner. Let them identify, mark it on a map showing which were the 6 pieces of land which were converted by the deputy commissioner. Please give it. We will see whether they would be satisfied with that survey, and thereafter we will direct them to accordingly make an entry in the Akarband. It should be carried out in the Akarband and Durast. Now, how can they say no? We don't find any record? This is totally misleading the court. How are they concerned at this point of time whether there was an original grant made or not? How are they concerned with that now? Adan tagakudi. The Tahsildar and ADL are present before this court. After hearing the learned counsel for petitioner and the learned HCGP for some time, this court finds that the petitioner company has purchased four pieces of converted lands all situated in survey number 46 and 47 of Aitore village, Kundana Hubli, Devanhalli Taluk, under a registered sale deed dated 28/11/2007. Stop. The learned HCDP has stated on verification of the original records that the 6 conversion orders that are filed along with the writ petition at annexures Q42
24 series. 24 series.
in Q4 series are found in the original records. So, next para. If the order of conversion passed by the Deputy Commissioner in the year 1998 is admitted, 1998 and thereafter is admitted, then relevant records and reports of the Tahsildar before the order of conversion to be passed by the Deputy Commissioner should have been made available to the Deputy Commissioner. Stop. The Tahsildar and the ADLR who are present in the court are hereby directed to identify the 6 pieces of land that were converted by the Deputy Commissioner in the documents found at annexures Q4 series, mark them on a map and present the same before this court on the next date of hearing. Stop. Release this matter on 14th of October 2022.
Okay. Next week, 14th. 21st.
21st of October. Have you taken notice thrice? Current counsel for the petitioner submits that appropriate application seeking permission to take out substituted service will be filed on behalf of the petitioner. 2 weeks time is granted to do the needful.
Serial number 27, my lord.
Copy bandidare, writ petition copy bandidya. Learned AGA submits that he has received copy of the writ petition. Interim order granted earlier stands extended.
My lord, serial number 27, my lord.
My
lord, I am representing respondent number 5, my lord. The connected 2 writ petitions are there in the similar set of facts. Between the same family members filed the writ petitions, my lord, with respect to cancellation of grant. It may be listed along with this writ petition, my lord.
Number
WP number 2794/2022 and 2885/2022.
This matter along with WP number 2794 of 2022 and 2885 of 2022.
Appear for the petition in this case, my lords. Pray for 2 weeks' time to comply with the office objections, my lords.
Finally, 2 weeks are granted at the request of learned counsel for petitioner for compliance of office objections.
Copy to be provided. I have obtained the same on obtained the copy.
Certified copy of Annexure E. This is the order under challenge. Under the Right to Information Act. Office has raised objection regarding non-production of certified copy of the impugned order dated 17/3/2020 at Annexure E. Stop. Learned Counsel submits that since the order was passed ex parte. 79 AB is the order was ex parte and the petitioner did not know of the impugned order being passed. The petitioner filed an application under the Right to Information Act and Annexure E has been obtained under the Right to Information Act. Full stop. Next para. Office objections are overruled. Achana. Disposed of. 79 AP.
Number 4, number 4 of the
Instead of mentioning grandfather of respondent number 5, A.K. Abraham, it is mentioned as father of respondent number 5.
Yes.
C. George.
Yes, ma'am. Yes, ma'am. I have produced the document, madam, Annexure R1, to show that it is.
Yenappa? Any objection? Order on. Memo for being spoken. This writ petition was disposed of by order dated 13th of September 2022. So, however, a typographical error is found at the paragraph number 4. So, Learned Counsel for respondent number 5 submits that instead of saying inverted commas grandfather of respondent number 5 dash Shri A.K. Abraham, close commas. It is mentioned as inverted commas father of respondent number 5 dash Shri George, close commas. So, next para. Learned Counsel for the petitioner has no objection to make the said correction. Full stop. Next para. Accordingly, office is directed to make necessary corrections and issue a fresh certified copy. Weeks are granted finally for compliance of office objections. Copy ಬಂದಿದೆನಪ್ಪ? ಕೊಡಿ.
Already I had produced my time of.
ಆಯ್ತು ಕೊಡಿ. Learned AGS submits that he has received copies of the writ petition. List this matter after service of notice on respondent number 5. Interim order granted earlier stands extended till the next date of hearing.
Appear for petition in this case, my lords. Pray for 2 weeks time to comply with the objection, my lords.
Finally, 2 weeks are granted. Yes.
Much obliged.
79 AB. 15. Sorry, disposed of. Yes. Allah sir, there are three other objections raised. The following office objections are yet to be complied. There are three other office objections. 2 weeks are granted at the request of learned counsel for petitioner for compliance of office objection.
Ramesh for R3 and 4 undertakes to file a wakalat.
Learned counsel Shresh Sangamesh RB undertakes to file wakalat for response number 3 and 4. Learned counsel for the petition, learned AGA submits it. He has received copies of the writ petition. Yes. Copy ಬಂದಿದ್ಯಾ? ಬಂದಿಲ್ಲ. Learned counsel for the petitioner is once again requested to serve a copy of the petition on the learned AGA. Stop. List this matter after service of notice on response number 6 to 8. Copy ಬಂದಿದ್ಯಾ? The AGA submits that he has received copy of the writ petition. List this matter after service of notice on response number 5 to 10. Interim order extended. The counsel for the petitioner has filed a memo dated 28/9/2022 stating that the respondent deputy commissioner has passed has reserved the matter for orders, and therefore the prayer made in the writ petition has become infructuous. Full stop. Next para. The memo is taken on record subject to all just exceptions. Accordingly, the writ petition stands dismissed as having become infructuous. This matter of service of notice on response number 2. The matter stands extended. That AGA submits that he has received copies of the writ petition. ಅಲ್ಲ ಅದಕ್ಕೇನೆ if you had implemented them ಮಾಡಿದ್ರಾ ಆ issue notice on IA number 1 of 2022. Of the objection is overruled. Yes. When was the mutation entry made?
So then I include the appeal, which came to think about the disposal of on complete 2018. Not for the eviction order.
Learned AGA takes notice for response number 1. Issue emergent notice to response number 4 to 6. So learned AGF for response number 1 to 3 and 5 to 5 and 6. 1 to 3, 5 and 6. Issue emergent notice to response number 4. Learned comes for the petitioner is directed to serve a copy of the petition on the learned AG. No adjournments now.
ರೈತನಿಗೆ ಭೂಮಿ ಇದ್ದಂಗೆ ರೈತನಿಗೆ ಭೂಮಿಗೆ ಲಾಯರ್ಗೆ ಬಾಯಿ ಸರ್ ನಮಸ್ಕಾರ ಅದಕ್ಕೆ ರಜಾ ಆದ್ಮೇಲೆ ನಾನು ಯಾಕೆ ಹೀಗೆ ನಾನು ಮ್ಯೂಟ್ ಆಗ್ಬಿಟ್ಟು ಫೋನ್ ಬರೀ ಹಿಂದೆ ಮುಂದೆ ಆಗ್ತಾ ಇತ್ತು ಸರ್ ಅದಕ್ಕೆ ಬಂದೆ ನೀವು ಬೆಳಿಗ್ಗೆ ಹೇಳಿದ್ರೆ ಯಾವತ್ತು ಹತ್ತುವರೆಗೆ ಕಲ್ಲಿಗೆ ನೋಡಿದ ವ್ಯಕ್ತಿ ಇದೆ ಮೊದಲು ಇದನ್ನ ನಾನು ಓದಿದೆ ನಾನು ಎಲ್ಲ ಹೇಳಿದೆ ನಮ್ಮ ಪಾರ್ಟಿ ಇಲ್ಲೇ ಕೂತಿದ್ರಂತೆ ಇನ್ನ ಕೆಲವು ಗ್ರೂಪ್ ನಿಮ್ಗೆ ಬಂದಿದ್ದಾಗ ಬೆಳಗ್ಗೆ ನೀವು ಬೆಳಿಗ್ಗೆ ಹೇಳಿದ್ರೆ ನೋಡಿದ್ ಬರ್ತಿದ್ರೆ ನಾನು ನಾವು ಮುಗಿಬೇಕು ಅನ್ನಂಗಿದ್ರೆ ಆಗ್ಬೋದು ಅಲ್ವಾ ಕೋರ್ಟ್ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡೋದು
Petitioner, my lord. I have already served the copies, my lord. Acknowledgement, my lord, by mistake, it was enclosed along with the process memo itself by my clerk, my lord, my office.
Petition copy, serial number 43. Learned, HCGP submits that he has received copies of the writ petition. List this matter after service of notice on response number 7 to 9.
N and P, my lord, may kindly be dispensed with for the time being. I have produced annexure N and P mutation and RTCs, my lord.
No, no.
Wait, hold on.
Matter is called out. There is no representation for the petitioner. Is this matter after? Come like that. If you had filed an application for impleading,
To intervene.
it says for permission.
Yes, sir. Permission to intervene.
Let us see. Yes.
45 Vardarajan, yes. 45.
2 weeks are granted for complaints of office objections. For the matter is that Ex-serviceman. Who was ex-serviceman?
The husband of petitioner is a widow of the ex-serviceman. There was an order given after 1951 to the Lord.
When did the petitioner die?
Petitioner died on 2021. That will be
17/1/2021.
17/1/2021. He has 3 children. Both sons also died. That is why they were contacting me. I was unable to contact them. Then, when I said,
Then who are these?
they are the grandchildren. I mean, one is the daughter. The third. One, two, three, four. And 5 are the wife and children of the son. Of the petitioner. 6 is the daughter of the petitioner. Again, 7, 8, 9, 10 are the wife and children of the son, another son.
Orders on IA number 123 of 2022. These applications are filed. Putting on record the legal representatives of this petitioner, while condoning the delay and setting aside abatement. The petitioner, Srimati Makbul Jan, who is the widow of an ex-serviceman, late Sri Nizamuddin, had filed this writ petition, claiming grant of land So, the petitioner died on 17/1/2021, and these applications are filed on 24/9/2022. There being a delay of 604 days. Although this court is not convinced with the explanation sought to be offered for the delay in filing the application, nevertheless, having regard to the fact that the petitioners, the applicants seek to take forward the application filed by Srimati Makbul Jan for grant of agricultural lands and the right to sue survives on them, this court proposes to allow the application for condonation of delay while imposing costs. Full stop. Next para. Consequently, the delay is condoned by imposing costs on the applicants, and they are directed to pay rupees 2,000 as cost to within a period of 2 weeks from today. A copy of the acknowledgement for receipt for having paid the costs shall be filed in the office. As per abatement is set aside, and consequently the application is allowed, permitting the legal representatives of the petitioner to come on record. So, Learned Counsel for the petitioner shall carry out the amendment in the cost title and furnish amended cost title within a period of 2 weeks from today. Next para. The petitioners are directed to take out hand summons to respond number 4. Yes.
47. It is noted, P1 and P2. No for return.
Move for retirement filed by advocate for petitioner. ಇವರು ಪರಾ ಫಾತಿಮಾ ಅವ್ರು ಹಾಕ್ತಿರೋದ. Since Learned Counsel Shri SP Thotar. ಎಷ್ಟು ಜನ petitioners ಇದ್ದಾರೆ? Has entered appearance for the petitioners by filing NOC Wakalat, the name of Learned Counsel Srimati Para Fatima may be removed from the cause list. Next.
The applications are filed. Bring the LRs on record and give us an abatement.
Respond number 7. Notice order agita. They were earlier appearing. Notice servagidya. Notice whether notice was issued at all. Correct. Yes. Correct. Whether notice was directed, then if he says yes, I'm instructed to appear on behalf of them, yes, issue notice on IAS number 123 of 2022. And what about in the meanwhile, steps shall also be taken in respect of respond number 6. Yes. Let us see. Yes, sir. Finally, 2 weeks are granted to take fresh steps in respect of respondent number 5. Huh? I recorded it last time also. How can you go on making this kind of submission? No, my lordship. Though the matter was adjourned at the request of learned counsel for petitioner on the last date of hearing, with an understanding that the matter will be heard and disposed of finally. Nevertheless, a submission is made on behalf of the learned counsel for petitioner seeking one more adjournment on the ground that the learned counsel is not well. No, Andra. Huh? Yes, really. Yes. One minute. Cancelling the survey and jurisdiction. (1974) 3 acres. 3 acres.
In the meantime, after grant of land, there is land came to be acquired. I show the.
I have heard this matter.
Land extend
I had directed. Learned AG is directed to secure this information and place it before this court by the next date of hearing. Bandidiya? Yes. Let us see what is the report submitted with the. Copy दिया Allah. You have filed a memo on 18/8/2022 along with the certified copy. of a 4161 notification along with survey sketch to show the place left for Nala in the land. ಅದರಂತೆ ಹಾರನಹಳ್ಳಿ ಹೋಬಳಿಯ ಸುಂಕದಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 7ರಲ್ಲಿ ನಾಲಾ ಉದ್ದೇಶಕ್ಕಾಗಿ ಭೂಸ್ವಾಧೀನವಾಗಿರುವ ದಾಖಲೆಗಳ ಮಾಹಿತಿ ಮತ್ತು ಭೂಸ್ವಾಧೀನಗೊಂಡಿರುವ ಜಮೀನಿನ ಖಾತೆದಾರರುಗಳಿಗೆ ಪಾವತಿಸಿರುವ ಪರಿಹಾರದ ಮಾಹಿತಿ ಈ ಕಚೇರಿಯಲ್ಲಿ ಲಭ್ಯವಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಸದರಿ ಮಾಹಿತಿಯನ್ನು ತುರ್ತಾಗಿ ನೀಡುವಂತೆ ವಿಶೇಷ ಭೂಸ್ವಾಧೀನಗಳು ಮತ್ತು ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರಿಗಳ ಕಚೇರಿ ಮೈಸೂರು ರವರಿಗೆ ಪತ್ರ ಕಳುಹಿಸಿದೆ. ಅದಲ್ಲ, ಕಾಂಪನ್ಸೇಷನ್ ಹೋಗಿರೋದಲ್ಲ. They were required to furnish information as to how the Nala has passed, what extent of land of each of you has gone for Nala portion. That is what we wanted to know. Okay?
After acquisition of land, the Nala came reconstructed.
ಆಯ್ತು.
Was done by the PWD. The extent of
Correct, sir. Adadmele, after the construction of the Nala, how much extent of land of each of you has gone is the question. Avudalla. A survey has to be done and it has to be found out. It was done in the presence of all the parties, right? ಹೌದು ಇದೆ. ಇದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದಾರ ಅವರು.
ರಿಪೋರ್ಟ್ ಪ್ರಕಾರ ಖಾತೆ ಮಾಡಿ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. ಈ ರಿಪೋರ್ಟ್ ಪ್ರಕಾರ ಈಗ ಬ್ರಿಟಿಷರಿಗೆ ಉಳ್ಕೊಂಡಿರೋದು 1 ಎಕರೆ 26 ನಮಗೂ ಉಳ್ಕೊಂಡಿರೋದು ನಮಗೆ 1 ಎಕರೆ 7 out of 2 acres, we are ready to do that. They are accepting it. ಇವರು ನಮಗೆ ತೊಂದರೆ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. ನಾನು 2.5 ಎಕರೆ
ಬರ್ಕೊಳ್ಳಿ. Release this matter on 30th of September 2022 for orders. Stop. No further adjournments will be granted at any cost. Banni naadi banni, let us see. Banri naadi banri ಏನು extend ಮಾಡೋದು? Yes. Repeal of the
The entries continued in the RTC records. So we made an application to the Tahsildar to remove the entry. He has issued an endorsement to file an appeal under 136. That cannot happen. The last has held that you have to go to the deputy commissioner to speak redress.
Where is that order?
On the age of the act. I can tell you this question is not taken on the date of the repeal of the act. So the deputy commissioner has to decide Number 14. So you are to go before the Deputy Commissioner. Okay. Next, your H is page number. Next, H, my lord. 06. How are the petitioners related to this Shantama? They are the subsequent players. Petitioners 1 and 3 and grandfather of petition number 2 purchased this property. Shantama. The petitioners are aggrieved by the imputed endorsement dated 9/3/2020 at annexure H issued by the Special Tahsildar, Bangalore East Taluk, KR-Puram. Stop. Next para. The petitioners had approached the Special Tahsildar seeking deletion of the entry in the land revenue records, in the record of rights of the name of the government, while including their names in the record of rights pertaining to survey number 123/1, extent 2 acres 10 guntas, survey number 118/2, extent 16 guntas, and a topic. Stop. The counsel for the petitioner submit that consequent to the repeal of the Urban Land Ceiling Act,
by the urban land bracketally ceiling and regulation close ಇನ್ನೊಂದು bracketally repeal close act 1999. The petitioners approached the special Tahsildar requesting for deletion of the name of the government from the record of rights. So, the Tahsildar, while issuing the impugned endorsement, held that the petitioners are required to file an appeal under section 136 bracket 2 of the Karnataka Land Revenue Act, 1964. So, next para. Learned counsel for the petitioners draws the attention of this court to a recent decision in the case of Srimati Shantama and others versus the state of Karnataka and others in WP number 134 of 2020, dated 22nd of January 2021. Stop. Next para. In the said decision, this court noticed a decision of the division bench in the case of Srimati Mallamma versus the state of Karnataka Revenue Department and another, reported in ILR 2008 Karnataka 4041. Wherein it was held that section 3 bracket 2 of the Repeal Act provides that where any land is deemed to have vested in the state government under subsection 3 of section 10 of the Principal Act, but possession of which was not taken over by the state government or any person duly authorized by the state government or by the competent authority, and any amount has been paid by the state government with respect to such land, then, such land shall not be restored unless the amount paid is refunded to the state government. Stop. The division bench also held that even if possession is taken over, but there was no determination of compensation, and therefore, if compensation is not paid, the benefit of the saving clause of the Repeal Act should flow to all such persons. Stop. However, it was also brought to the notice of this court that the state government has clarified the procedure to be followed in certain cases relating to the Repeal Act. Stop. In terms of the said communication, where possession of the land has not been taken, the owner will get the benefit in consonance with the provisions of subsection 2 of section 3 of the Urban Land Sealing and Regulation Clause Repeal Act, 1999. Stop. In such cases, it was directed that the entries, if any, made in the RTC in favor of the government will have to be rescinded. Stop. It was also directed that applications have to be made before the Deputy Commissioner under the provisions of the Repeal Act, 1999. Stop. Learned Council submits that the matter stands covered on all fours in the said matter, in the said decision. Stop. Next para. Para number 15. Repeat. Same. Yes. ಅಲ್ಲಿ ಹಾಕಿದೀವಿ ಅಂತ ಕಾಣುತ್ತೆ.
ಟೈಮ್ ಲಿಮಿಟ್ ಹಾಕಿಲ್ಲ. ಟೈಮ್ ಲಿಮಿಟ್ ಹಾಕಿ.
The Deputy Commissioner shall pass necessary orders as expeditiously as possible and at any rate within a period of 3 months from the date when the application is given by the petitioner. Yes. Yes. Huh? Yes. ಏನ್ ಹೇಳ್ತಾರೆ ಈಗ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ?
ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಅಷ್ಟೇ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ. Kindly see the order passed by this court on 15/12/2021. This court specifically directed
whether there is an existence of tank,
land also. In order
whether there is any cultivation.
Please. I brought to the notice of the court, there are standing trees of 35 years old. Standing trees are there in the property in question. That has not been reported in the survey report. Must may kindly see the order passed by this court on 15/12/2021.
Yes, I saw that.
ಅದನ್ನ ಏನು ಹೇಳದೇ ಇಲ್ಲ. ಕಟ್ಟೆ ಇದೆ ಅಂತ ಅಷ್ಟೇ ಹೇಳ್ತಾರೆ.
ನೀವು ಟ್ರೀಸ್ ಬಗ್ಗೆ ಹೇಳಿದ್ರಾ?
ಹೌದು. ಅವೇನು ಹೇಳೋದಿಲ್ಲ.
ಇಲ್ಲ ಹೇಳಿದ್ರೆ?
The order of this court on
shall also
15th last day.
report if any portion of this land is cultivated for any purpose and whether any trees stand on the land.
ಇದನ್ನ ಏನು ಹೇಳೋದಿಲ್ಲ.
ಏನಂತ ಹೇಳಿದಾರೆ? ಎಲ್ಲಿ ಓದಿದ್ರಿ ನೀವು? ಹೆಚ್ಚ? ಹಾ ಹಾ ಒಂದು ಕಾಲಮೇ ಹಾಕ್ಬಿಟ್ಟಿದಾರ ಅಲ್ಲಿ.
ಹೌದು, ಕೋಕೋನಟ್ ಟ್ರೀಸ್ 30.
ಹೌದು, ಎಲ್ಲಾದ್ರಲ್ಲೂ ಪ್ರತಿಯೊಂದ್ರದ್ದು ಕಾಲಮೇ ಹಾಕಿದ್ದಾರೆ. ಕೋಕೋನಟ್ ಟ್ರೀಸ್ ಆಫ್ 30 years.
ಹೌದು.
ಬಸವರಾಜ್ ಅವರ ವಿಚಾರದಲ್ಲಿ ಕೋಕೋನಟ್ ಟ್ರೀಸ್ ಆಫ್ 30 years ಬಂದಿದೆಯಲ್ಲ.
ಇದು ಏನಾಯ್ತು ಅಂದ್ರೆ, I will make the facts before the court.
An
application was moved before the committee for regularization unauthorized cultivation. Total extent available survey number 31 is 14 acre 11 gunta.
ಅಲ್ಲ ಸರಿ, if it is a tank, it could not have been granted. That is what they are saying.
Tank ಈ ವರ್ಷ ಒಂದು ಆ ನೀರು ಇರೋ ಜಾಗ ಬಿಟ್ರೆ
ಅದಲ್ಲ ಪ್ರಶ್ನೆ, ಅದಲ್ಲ. Not whether there is water filled now, ಅದಲ್ಲ ಪ್ರಶ್ನೆ. If it is earmarked as a tank area, that could not have been granted by the committee. That is the contention raised.
Was the contention.
ಅದನ್ನ ವೆರಿಫೈ ಮಾಡೋದಕ್ಕೆ they were asked to make a survey. In fact, it is not the survey. What was required was to furnish the records to show whether this area was earmarked as a tank.
ಇಲ್ಲ ಅಂತ ಹೇಳಿ ತಹಶೀಲ್ದಾರ್ ರಿಪೋರ್ಟ್ ಹಾಕ್ತಾರೆ. Annexure C page 21. Annexure C
ಟಿಪ್ಪಣಿ ಕಾಪಿ ಹಾಕಿದಾರಾ? As per the original survey, ಏನದು
ರಿಪೋರ್ಟ್ ಆಫ್ ದಿ ತಹಶೀಲ್ದಾರ್
ಆಗದಿಲ್ಲ. ಅದನ್ನೇ ಅವ್ರು ಹೇಳಿರೋದು ಸಾಹೇಬ್ರು. ಈ ತರ ಒಬ್ಬೊಬ್ರು ಅವ್ರವ್ರು ಇಷ್ಟ ಬಂದಂಗೆ ಏನೋ ಬರ್ದಿದ್ದಾರೆ. We can't go by that one. We can't go by an endorsement issued by the Tahsildar.
Endorsement issue.
Therefore, what was directed was to find out whether there was an existence of a tank as per the records.
Please.
Now they say 4 acres and 11 guntas as per the original survey records is a tank bed area in survey number 31.
ಹಂಗಂತ ಹೇಳಿ ಈಗ ಕರೆಕ್ಟ್. ಅದನ್ನ ಏನ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು ಅಂದ್ರೆ, I can understand if proceedings have been taken by the committee, rejected our application, matter could have been quite different. You must may kindly see the order dated 11/2/2004, passed by the committee regularizing our cultivation. Pursuant to this, Tahsildar passed an order on 20th January 2004, entering the content has to be deleted and Sarkar delete ಮಾಡಿಬಿಟ್ಟು it has to be cultivated land ಅಂತ ಮಾಡಿ, then we have been asked to pay the occupancy price.
ಮಾಡಕ್ ಬರಲ್ಲ ಹಂಗೆ
ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ. ಹಂಗಾಗಿ ಆದ್ಮೇಲೆ after 10 years, these respondents went to 13. filed an appeal before the assistant commissioner.
Hmm.
This is the grievance of the petitioner before this court.
Application seeking what?
Appeal, questioning our grant.
Correct. They are saying it is a tank area, it could not have been granted anta. They are not asking for grant in their favor.
Illa.
They are saying it's a tank area, it could not have been granted anbuto.
Please, kindly see annexure H page 75. Not 8 I ಕೆಳಗಡೆ certain land should not be granted ಅಂತ ಇದೆ.
Yes.
ದೇವರ ಕಾಡು, ಉರುಡುದವೆ, ಗುಂಡುತೋಪು, ಟ್ಯಾಂಕ್ ಬೆಡ್,
Correct.
ತರ ಬಳ್ಳ. ಇದಕ್ಕೆ ಒಂದು ಎಕ್ಸೆಪ್ಷನ್ 108N. Notwithstanding anything contained in this chapter, the state government may suo motu
108 N.
108N.
N.
Powers of the state government. Notwithstanding anything contained in this chapter, the state government may suo motu or on a recommendation of the divisional commissioner or the deputy commissioner, if it is of the opinion that in the circumstances of any case or classes of the cases, it is just and reasonable to relax any of the provisions of these rules, it may by order direct such relaxation, recording reasons for such relaxation, subject to such conditions as may be specified in the order thereupon. Land may be granted in such a case or a class of cases in accordance with such a direction. ಇದರಲ್ಲಿ ನಮ್ಮಲ್ಲಿ ಏನ್ ಮಾಡ್ಬೇಕಾಯ್ತು ಅಂದ್ರೆ Tashildar should have sought clarification of the deputy commissioner. Instead of doing that, he himself has done it. If that were to be the case, what is the course open for the authorities concerned? Your lordship kindly see. An identical issue.
ಅದು ಡೆಪ್ಟಿ ಕಮಿಷನರ್ಗೂ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
ಗವರ್ಮೆಂಟ್ ಬರ್ಬೇಕಾಯ್ತು.
ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಹ್ಯಾಡ್ ಟು ರೆಕಮೆಂಡ್ ಟು ದಿ ಗವರ್ಮೆಂಟ್.
ಅದನ್ನ ಮಾಡ್ಬೇಕಾಯ್ತು. ತಹಶೀಲ್ದಾರ್ ಲೆವೆಲ್ ಅಲ್ಲಿ ಮಾಡಿದ ತಪ್ಪು.
See, that is the deviation that is being pointed out now in the wake of this large scale waterlogging that took place recently. Now allegations are being thrown from one government to the other. ನೀವು ಆ ಕಾಲದಲ್ಲಿ ನೀವು ಪರ್ಮಿಷನ್ ಕೊಟ್ರಿ, ನೀವು ಮಾಡಿದ್ರಿ, ಅದು ಇದು ಅನ್ಬಿಟ್ಟು ಇದೆ. This is the provision. This is the provision that they are pointing out to. So therefore, at any stretch of imagination, the Tahsildar has no power. The committee also could not have granted it unless it was de-reserved in accordance with this provision.
The correct provision would be, after the order passed by the committee, Tashildar should have seek clarification from the government before issue of this abatement. If it is not done, what is the course open to the authorities?
Yes.
It's a case where the burial ground which is not to be granted. Kindly take paragraph number 2. The grievance of the petitioner in Gulshur village has been submerged in Malaprapa project. Village of the said village have been rehabilitated to Rampura state in Saudanti, and the land bearing survey number 18/B situated at Gulshur village measuring 2 acres had been earlier reserved for burial ground, and after shifting of the said village to Rampur, burial ground has lost its characteristic, and as such the same having been left unused, and as such it was being cultivated by the father of the petitioner by investing huge amounts for more than 35 years. And on the demise of the petitioner's father, petition has been continued to cultivate the same, and in view of the cultivation being done in the said land, notice for recovery of the land revenue came to be issued in form number 37 on 97/1970 by the revenue inspector as per annexure B to the deceased father of the petitioner.
ಅದು facts ಆಯ್ತು.
Kindly go to paragraph number 3. It is also contended the petitioner has continued to cultivate the land on the demise of his father. Certificate issued by the village accountant as per annexure D would evidence the fact of seeking for a grant of said land. Petition also filed the form number 1 on 2/6/2011, and as such the petition is man number so and so, paragraph number 4. Per contra, the state has filed objection contending in the area that in the question is a burial ground. That is bar under section 108, rule 108I of the Karnataka Land Rules 1966 for grant of either to the petitioner or to anyone as such the petition is not entailed for so and so. Having heard the learned counsel for the petition appearing for the parties on perusal of the case paper, as well as statement of objection filed by the respondent, it would indicate already on the Madidmele, paragraph number 6. However, it is non-dispute on accounting of shifting of the inhabitants of Bulsuri Rampur burial ground is also said to have been abandoned and not being used as such. The deceased father of the petition is stated to have been cultivating the said land. In the light of the certificate having issued by the village account Bulsuri annexity certifying the petition has been cultivating the said land in question, it will suffice that if the direction issued to the respondent to examine the claim of the petitioner as to whether the said land having lost the characteristics of burial ground is available for being granted, and if so, the respondents are liberty to consider the claim of the petitioner and proceed to pass orders thereon in accordance with the provisions of rules 1966, Karnataka Land Grant 2016, governing the such grant. This is what I wanted to make it submission.
ಅದು ಬರಿಯಲ್ ಗ್ರೌಂಡ್, ಇದು ವಾಟರ್ ಟ್ಯಾಂಕ್, ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಸಂಬಂಧನೇ ಇಲ್ಲ. ಸಿ ವೇರ್ any impact would be had on the environment, this court is not going to be a party to these kind of orders. The Supreme Court has been coming down very heavily, and all orders are being passed to ensure that environment is protected. So various statutes have been framed consequent to the directions issued by the Supreme Court. Every project that is to be undertaken, there should be a environmental impact report. So ಅಷ್ಟೆಲ್ಲ ಮಾಡಿದ್ಮೇಲೆ ನಾವು we can't say this tank has lost the character of a tank and therefore we will permit that to be used as agricultural land. Consequences will be this disaster.
My only submission before the court, if our application be rejected on the earlier threshold itself, we could
ಸರಿ ಆಯ್ತು, ಏನ್ ಮಾಡೋದು? what to be done?
We have grown the trees 35 to 40 trees.
That's all right.
40 years trees are there.
ಇಲ್ಲಿ ಮನೆಗಳೇ ಹೋಗ್ತಾ ಇದಾವೆ. You are talking of standing trees. Buildings are being demolished. You have seen at the directions of the Honorable Supreme Court, 2 huge buildings were demolished. One in Kerala and another one recently in somewhere in the north. ಏನ್ ಮಾಡೋದು?
10 ವರ್ಷ ಆದ್ಮೇಲೆ ಇವರು ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂಡು appeal before the assistant commissioner after 10 years from the date of grant, without there being an application for condonation of delay, even that also
ಅದೆಲ್ಲ ಬರಲ್ಲ ಸರ್. Fraud vitiates everything.
certainly. ನಮ್ಮ ಕಡೆಯಿಂದ ಫ್ರಾಡ್ ಆಗಿಲ್ಲ.
ಅಲ್ಲ, ನಿಮ್ದಲ್ಲ. Whoever granted you this land, fraud has taken place at their hands. You may not be knowing.
Please.
We will accept that. You may not be knowing.
If our application has been rejected at the threshold itself, we could not have been approached this honorable court for last 13 to 20 years.
Yes.
And after 10 years from the date of the grant, these villagers said to have been paid an appeal before the assistant commissioner challenging our grant. And there is no application for condonation of delay also. Instead of that, the appeal came to be allowed. And I have been directed to evict from the property in question.
We will direct them to see if any alternative land can be given to you. That is the maximum that can be done. Please. Perfect.
ಡೆಪ್ಟಿ ಕಮಿಷನ್ ಏನ್ ಹೇಳ್ತಾರಂದ್ರೆ, ಸರ್ಕಾರದಿಂದ ನಿಮಗೆ ಮಂಜೂರಾತಿ ಸಿಕ್ಕಿಲ್ಲ, ಹಾಗಾಗಿ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಅಂತ ಹೇಳಿ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಹೇಳ್ತಾರೆ.
ಅಲ್ಲ, ಇವಾಗ ಇನ್ ದಿ ಪ್ರೆಸೆಂಟ್ ಪೊಸಿಷನ್ ಐ ಡೋಂಟ್ ಥಿಂಕ್ ಇವನ್ ದಿ ಗವರ್ಮೆಂಟ್ ವುಡ್ ಟ್ರೈ ಟು ಪಾಸ್ ಎನಿ ಸಚ್ ಆರ್ಡರ್. The petitioners are aggrieved by the impugned order dated 25/4/2017 passed by the Assistant Commissioner, Hassan Subdivision in proceedings bearing number RA (Cha) close 14 for 2014-15 at annexure H.
Annexure J1 Deputy Commissioner order.
And the subsequent order of the Deputy Commissioner dated 12/8/2021. Some of the admitted facts the petitioners had made applications seeking regularization of unauthorized occupation, and the Committee for Regularization of Unauthorized Occupation of Chandrayapatna Taluk had passed orders conferring grants in favor of the petitioners, in the year 2004. However, at the instance of the contesting respondents herein, proceedings were initiated before the Assistant Commissioner in the year 2014 for cancelling the grants made in favor of the petitioners, on the ground that survey number 31, measuring 14 acres and 11 guntas, situated at Nandipura village, in which the lands were granted in favor of the petitioners, is a tank bed area, and the said lands could not have been granted in favor of any persons. So, proceedings were initiated in terms of Rule 108D, and the Assistant Commissioner held that the revenue records would indicate that 14 acres and 11 guntas were earmarked as katte, and the Committee for Regularization could not have ordered grant of the lands in the said area. Stop. The appeal was allowed, and the grants made in favor of the petitioners were cancelled. So, the revision petition filed before the Deputy Commissioner at the hands of the petitioners herein were rejected by order dated 12/8/2021. Full stop. Next paragraph. Learned counsel for the petitioners submits that the Tahsildar had submitted a report before the committee to take a decision on the applications filed by the petitioners. So, in terms of the report of the Tahsildar, it was found that the petitioners were in unauthorized cultivation of the lands. Stop. It was not reported by the Tahsildar that the area is a tank bed, and neither did the petitioners know that the lands form a portion of the tank bed area. Stop. Learned counsel would also submit that even if the land in question was earmarked as a tank bed, nevertheless, it is clear from the records, from the available records, that there was no existence of a tank even during the year 2004 or previously. Full stop. That itself is sufficient to say that even if the area was earlier reserved as tank, it can be stated with conviction that there was no water body existing, and the land had lost the characteristics of a tank. So, Learned counsel, therefore, seek to place reliance on a decision of this court rendered at Dharwad bench in the case of Ningappa Durgappa Madar versus the state of Karnataka and another, reported in 2015/2 Karnataka Law Journal 126. So, Learned counsel submits that this court noticed the provisions contained in Rule 108I of the Karnataka Land Grant Rules and held that the matter could be re-examined since the land in question had lost the characteristics of a burial ground, and it could now be made available to the parties to the applicants. Stop. Learned Counsel would also draw the attention of this court to Rule 108N. Which reads as follows. Extract mode. The Learned Counsel would therefore submit that if it was permissible for the state government to pass necessary orders, having secured the recommendation at the hands of the revenue authorities, only because necessary permission was not taken in terms of Rule 108N, the petitioners should not be dispossessed and displaced as this at this point of time. That is nearly $18 years after the land was granted. After the grant.
After the grant, 2004.
18 years after the grant was made in favor of the petitioners, and nearly 30 years after the petitioners had started cultivation of the lands, which is evidenced by the report submitted by the Assistant Director of Land Records, in terms of the memo dated so and so. Memo dated 24/1/2022. Filed at the hands of the learned HCGP. Stop. Learned Counsel submits that the fact that there are coconut trees aged about 30 years and more standing on the lands in question would clearly establish the fact that for more than 30 years now, and even till this day, there is no water accumulated in the lands in question. Stop. Next para. Having heard the Learned Counsel for the petitioner, and on perusing the petition papers, including the report submitted by the Assistant Director of Land Records, this court finds that the factual abatements made at the hands of the Learned Counsel for petitioners may be correct. Full stop. However, the decision sought to be relied upon by the Learned Counsel for petitioner is in a context of a burial ground, and that after the lands were submerged by waters, and thereafter the area earmarked for burial ground was never used as a burial ground. The directions were issued by this court to examine as to whether post facto orders could be passed, taking note of the changed circumstances. Stop. However, in the present case, we are dealing with a situation where the land is earmarked as water tank. Stop. This board cannot lose sight of the fact that the Honorable Supreme Court has issued various directions in the matter of protection of environment, be it forest lands, water bodies, etc. This court is of the opinion that having regard to the fact that merely because a tank was not filled with water for a long time, if the revenue authorities proceed to hold that the land has lost the characteristics of a tank and make recommendations to the government, such recommendations are dangerous to be acted upon. Stop. This, is something that is to be noticed having regard to the natural calamities that we are witnessing in the recent past. So, therefore, this court is of the considered opinion that if a land is earmarked as a water tank, even if there is no water logging for many years, the said lands should not be divested for any other purpose. So, however, the grievance of the petitioners should also be kept in mind. Stop. Next para. In the light of the above, this court is of the considered opinion that while sustaining the impugned orders passed by the Assistant Commissioner and the Deputy Commissioner, nevertheless, alternative arrangements will have to be made for the petitioners. Stop. Therefore, this court would direct the respondents, Tahsildar, and the Deputy Commissioner, Hassan District, to identify any other alternative lands for the petitioners and make recommendations to enable the petitioners to have an alternative, alternative lands. Stop. This court does not find any fault with the petitioners, and therefore this action is required to be taken at the hands of the respondent state government. Stop. Next para. The respondent Tahsildar, Chandayapatna Taluka, and the Deputy Commissioner, Hassan District are hereby directed to identify alternative lands which are suitable for agriculture for the petitioners, and pass necessary orders of a regrant in favor of the petition as expeditiously as possible, and at any rate within a period of 6 months from the date of receipt of a copy of this order. Ordered accordingly.
Station of the petitioner.
Huh?
Station of the petitioner. Right being.
The protection ಎಲ್ಲಿ ಬರುತ್ತೆ? ಸರಿ, ಏನ್ ಮಾಡೋದು?
Has to be removed.
What? Want to remove the coconut trees?
I'm ಮಾಡೋದಿಲ್ಲ. I don't want to.
You know, you are not going to remove it. Only thing is, if there is any harvest that you want to take away, you can take it away. Better on sentence. The petitioners shall be permitted to harvest the crops that are grown at present, and in that regard, the petitioners are permitted to remove the crops within a period of 4 weeks from today. Yes.
I am back to petitioner, my lordship. I filed the IA for the implement of these 6 respondent number 6 and 5 and 6. Subsequent development after the filing of the petition, and though the interim order is granted by this honorable court, the respondent number 1 sold the properties in favor of one company, my lordship. That is a respondent number 5. I want to make it implemented as a respondent number 5. And the Tahsildar for respondent number 6, because of there is an order by this honorable court on 16th March of 2022. The direction was issued not to change any maintain status quo with the respect of the revenue entry.
Alala, whether notice was directed,
No.
it has to be issued.
It has to be issued.
Issue notice on IA number 1 of 2022 in respect of the proposed respondent number 5. Messrs. Grand Sky Infra Projects.
And
Planet HCGP is directed to take notice for the proposed respondent number 6, Tahsildar, Bangalore East Taluk. Yes.
Meanwhile, restraining the further alienation, my lordship, there is a threat of alienation is there, and direction may be granted.
They have recently purchased it. Where are they going to alienate it?
No, my lordship. They were the builders, my lordship. They were the builders.
We are not concerned with the alienation of the property. We are only concerned with the land revenue entries.
Yes, my lordship.
Whatever you want to do, you go and do before the civil court. Yes.
53 K. Ravishankar. An application for posting address covered by the document.
Where the top, which we have order.
That whether the assistant commissioner has got a power to recall
Which is
it.
that order? What is?
They have power to recall their own order. Is the question, it has been answered. Paragraph number 14, 16 and 22. Data has been changed in my name. Without notice, the assistant commissioner recalled its own order. That was called in question before the deputy commissioner. Deputy commissioner dismissed my appeal. It was called in question before this.
But there is also a recent decision of the division bench, which has held that there is power of review even with the revenue code. There is such an order. Huh? Notaries. I have come across that order recently. Division bench has held. The revenue codes are 25.
It is under section 136(2).
No. Power of review is inherent in view of the provision contained in section 25.
25.
Yes.
For cancellation of grant.
Whatever order, revenue courts are empowered to review their order.
I understood. Follow.
So this would be.
No, I shall look into it.
Please look into it. With this matter, immediately after Dasra.
Here we are challenging an order of the AD. In the Lena either, I had purchased the land. I was granted land. Then the deputy commissioner in 2011 initiated suo motu proceedings, found everything in order and dropped the proceedings. Subsequent to that, I made an application for 40 of my land. Nothing was done. Then I filed a writ petition in 2014. This court said, take necessary action to complete 40.
Original grantee was Nanjunda Shastri.
My ancestor, Nanjunda.
No, you are a purchaser, isn't it?
Yes.
How the?
Purchase.
You purchased the land in the year 1994.
Yes. I'm sorry. Originally belonged to Nanjunda Shastri. Then what happened was the Sagoli Chiti was issued on 10/7/1952. There appeared to be some discrepancy. The deputy commissioner initiated suo motu proceedings and dropped the proceedings, saying that everything was in order. If the lordship sees that page 59 is the order of the deputy commissioner, the first instance. I made an application for 40. Page 61 is the ultimate order. Harriet Jamin just since it is proved that it is legally given, therefore the proceedings are dropped. Then I made an application for 40. Nothing happened. Then I filed writ petition number 710. Please see page 69 is the first order of this court. At 70 and 71. For consideration of the representation, long lapse of time, directed to consider representation dated so and so in accordance law with 6 months. And Triga Vogeli documents la to move mad. Triga Yenu Madli. Triga was the involved writ petition. 64156, page 60. Nice. Please come to page
69.
Alban Mele, there again, the court directed you do something. Now what happens is, the deputy commissioner calls for a meeting, page 72. It's just a meeting. And
that is a meeting of the committee for missing records.
No, so they have a meeting. So then they say that page 84 to 87 is the operative portion. no order is passed. Then they issue a direction to the Tahsildar. Tahsildar issues me an endorsement at page 87.
Allala, in this order of the deputy committee,
Yes,
ಯಾವ portion ಅಲ್ಲಿ your case has been considered?
page 84. Page 84, Prakarana Sankhya 3. Page 84, last 3 lines. ಅಲ್ಲಿಂದ ಶುರುವಾಗುತ್ತೆ. ಬೆಂಗಳೂರು ಉತ್ತರ ಅಪ್ಪರ ತಾಲೂಕು. Then what happens is they say that the documents are not available, so it cannot be, OD cannot be done. No. I think 85. Second last page, 85. ಈ ದಿನದ ಸಭೆಯಲ್ಲಿ ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕು ಕಚೇರಿಯಿಂದ ಹಾಜರುಪಡಿಸಿದ ದಾಖಲಾತಿಗಳನ್ನು page 85. Second last paragraph of this page. Talk about Sadhuri Pudi Durati Vicharagi, so. Last page on the top, ಇದರಿಂದ ಸಭೆಯಲ್ಲಿ ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕು ಕಚೇರಿಯಿಂದ ಹಾಜರುಪಡಿಸಿದ ದಾಖಲಾತಿಗಳನ್ನು ತಹಸೀಲ್ದಾರ್ ಪರಿಶೀಲಿಸಿ ಆರ್ಆರ್ ವಹಿಯಲ್ಲಿ ಹಂಗಾಮಿ ಮಂಜೂರಿ ಎಂದು ದಾಖಲಾಗಿದ್ದು ಕಾಯಂ ಮಂಜೂರಿ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆ
ಲಭ್ಯವಿಲ್ಲದ್ದರಿಂದ ಪ್ರಸ್ತಾಪಿತ 6 ಎಕರೆ ಜಮೀನಿನ ಪೋಡಿ ದುರಸ್ತಿ ನಿರ್ವಹಿಸಲು ರಹ ಇರುವುದಿಲ್ಲವೆಂದು ಅರ್ಜಿದಾರರಿಗೆ ಕೂಡಲೇ ಹಿಂಬರಹ ನೀಡುವಂತೆ
ತಹಸೀಲ್ದಾರ್ ಹೇಳ್ತಾರೆ. So I challenge this minutes, saying that this is virtually an order. The KAT, page 15 is the order, says that it's only minutes of the meeting, there is no jurisdiction of the dismissal. My thing is to set aside the order and direct the KAT to consider my appeal. What I have no remedy. Either the committee should pass an order and pass an order. So I challenge the order. The Tahsildar is only carrying out issuing an endorsement. This is what the deputy commissioner said. The portion which has to be challenged is what the committee has decided. The KAT says,
but there is no provision for you to participate in the proceedings of the committee.
No, I'm not asking participation. Deputy commissioner should issue an order pursuant to the decision taken in the committee. I cannot be left without saying that you have no remedy to do what you want. Well, what happens is, I'm not saying no, you pass an order, whatever it is, but deputy commissioner being the head of that committee, you pass an order and say that no, we cannot do any coding, whatever he wants, let him write an order, but there should be an order for me to take the next step, whatever it may be, whatever right that may be available to me. Merely, and because what they say is only minutes of the meeting, it's not an order. It's virtually a direction. Not should we see the appellate tribunal order.
We'll have to see what can be done before the committee.
Yes.
See, it all depends on how and in what manner the government has constituted this committee. As far as I have seen in many matters, this recommendation of the committee, we have seen it's all in the similar manner. They only try to see whether there is any other documents available to build up the records. Ashte madakagodu, because it is constituted only for the purpose of building missing records.
Yes. My position is, you say there are no records. Now, unless you give me an order saying that there are no records, for me to take any further step, if you just take a decision in the committee and the Tahsildar issues an endorsement, where do I stand? The original Sagwadi treaty has been found to be in order, everything is in order, that's in 2011, that's what the deputy commissioner's order is there.
If that was there, then there was no,
That is exactly the point.
there was no reason for sending it to the committee for missing
No,
record.
what happened was, well, this is exactly what is happening. What happened was, till the deputy commissioner's order was passed, that is in 2011, Annexure G, nothing happened. Then once the deputy commissioner had started so much of proceedings, and then he said, yes, everything is in order, it's legally been given, he dropped the suo motu proceedings. After that, I thought it's the right time. Now there's no further thing. Let me have my land coded. Now, this is where I am saying that once the deputy commissioner himself says that yes, it is perfectly in order, for him to be party to a decision saying that no, I can't find records, then how is it? It doesn't stand to reason. Either the order of page 59.
Special deputy commissioner.
Please see page 61. He passes, he starts suo motu proceedings. And he passes the last page, Adesha, page 61. ಕಾರ್ಯಕರ ಜಮೀನು ಕಾನೂನುಬದ್ಧವಾಗಿ ಮಂಜೂರಾಗಿರುವುದು ಸಾಬೀತಾಗಿರುವುದರಿಂದ ಹಾಗೂ ತದನಂತರ ಕೆಲವು ಕ್ರಯ ಪತ್ರಗಳ ಆಗಿದ್ದು ಪ್ರತಿವಾದಿಗಳ ವಿರುದ್ಧ when it comes to sentences was done, there were savings, dropping the proceedings. How was this done? Like a lot without any. Now to say that no, we are not finding any documents is very easy and leave me. This is the order which is not. This order has remained untouched now for 11 years.
But by another government order, all these orders passed by the special deputy commissioners have been set aside.
At least they have said that the order is set aside. You tell me what it is with government will issue 100 orders a day, sitting somewhere in some.
No, that was considered by the division bench. The delegation of powers to special deputy commissioners who are not in the IAS cadre. That was questioned. Government found that all these special deputy commissioners were not of IAS cadre. They were all KAS cadre. The division bench considered that one, and during the course of this those proceedings, when they came to know that the delegation made by the government cannot be sustained, they recalled that order.
But instead, this is what happened before.
So no, in the final order it was considered. So that orders passed by the special deputy commissioners were rescinded.
As a farmer, you wrote an order now. You should have said there's a government order recalling all these. Nothing is said. Now they say documents not available. That is not the reason. Lordship have explained to me. The reason given here is not even that at all. I give it to Lordship is vast experience in this ALR matter. No, poor farmer is got everything. People are.
In fact, I was waiting for one such senior counsel to consider these kind of proceedings and initiation of suo motu powers under section 136(3). Is it only the case of changing the revenue records, or is it a case where you have been in possession of this land for decades together?
70 years.
So therefore, only by changing the records can you be removed from this land. Your possession cannot be disturbed like this.
Further problem.
Just because they are custodians of the revenue records, they are doing all these changes in the revenue records. But what about your position? How can they remove you from the position?
Then they come up with Tahsildar, ಹೋಗಿದ್ರು ನೋಡಿದ್ರು ಯಾರು
ಹಂಗೆಲ್ಲ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
People, they will think about it. Well, this is exactly what is happening. What people are being virtually harassed. ಇದು ನನಗೆ ಮೊದಲೇ ಹೇಳಿದ್ದೀನಿ, ಈ whole thing is bad ಅಂತ. ಅವಾಗ ಹೇಳ್ಬಿಟ್ಟಿದ್ರೆ ಆಗ್ತಾ ಇಲ್ಲ. ಅಲ್ಲಿಂದ 11-10 ವರ್ಷ ಆಗ್ತದೆ.
I think we have some decisions where it has been held that government cannot be kept in a special pedestal.
No, correct. Recently, I also agree that government cannot be kept.
So if it is agreed that one of its land has been encroached upon and some unauthorized person is squatting over it, he can be removed only in a manner known to law. Should they not seek any declaration? ನೀವೇ ಈ ತರದ ಏನಾರು ಅಡ್ವೈಸ್ ಮಾಡ್ಬೇಕು ನಿಮ್ ಕ್ಲೈಂಟ್ಸ್ ಗೆ. ಇವರು ದೇ ಗೋ ಆನ್ ಪಾಸಿಂಗ್ ಆರ್ಡರ್ಸ್, ಚೇಂಜಿಂಗ್ ದಿ ರೆವೆನ್ಯೂ ಎಂಟ್ರೀಸ್. 50 ವರ್ಷದಿಂದ ಇವರು ಮಾಡ್ಕೊಂಡು ಬಂದಿದ್ದಾರೆ. ನಿಮ್ಮ ಹೆಸರು ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಇದೆ. ಒನ್ ಫೈಂಡ್ ಸುವಮೋಟೋ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಂತ ಇನಿಷಿಯೇಟ್ ಮಾಡ್ಬಿಟ್ಟು
ಅದು ಗೆದ್ಕೊಂಡ್ ಬಂದ್ವಿ. ಅದಾದ್ಮೇಲೆ ನಮ್ ಕೋಡಿ ಮಾಡ್ಕೊಡಿ, ನೀವೇ ಎಲ್ಲ ಹೇಳಿದ್ರಿ, ಇವಾಗ ಕ್ಲಿಯರ್ ಕೋಡಿ ಮಾಡಿ ಅಂದ್ರೆ ನಾವು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಆರ್ ನಾಟ್. ಹೌ ಡಿಡ್ ಯು ಪಾಸ್ ದಟ್ ಆರ್ಡರ್? ಸಮಥಿಂಗ್ ಸಮ್ವೇರ್ ಸಮಥಿಂಗ್.
ಈಗ ಏನ್ ಮಾಡಿದಾರೆ ಇವರು?
ಇಲ್ಲ, ದೇ ಹ್ಯಾವ್ ಡಿಸ್ಮಿಸ್ಡ್ ಮೈ ಅಪೀಲ್.
ನೀವು ಇದನ್ನ this recommendation of the committee you sought to challenge before the KAT.
No, it's only a minutes of the meeting. It is not an order. We don't have jurisdiction.
So you are now asking for Kodi. So they have not removed your name from the land.
Kodi madak agalla. Maybe they have not yet come up with the criteria. Who knows who's looking for this property? I don't know.
Then but let us keep this pending. In the meanwhile, you see what advice you have to give to your clients.
I will do that.
Huh? At the request of the learned senior counsel, this is better after Dasra vacations. In the meanwhile, statement of objections shall be filed at the hands of the respondent state.
Well, though I have not asked for a prayer, in special circumstances, you should not precipitate the matter and do something else now in view of today's.
Madak baralla. That's what I'm saying.
Somebody madak baralla is one thing. Madak trigger ಇನ್ನೊಂದು expedition.
No. You see, there is nothing to enable them to remove your name from the records. No. If they do anything like that, you will get a cause of action.
I know.
Madi.
I represent petitioner, your lordship.
Yes.
Petitioner given representation to the second and third respondent, third and fourth respondent. Your lordship, kindly see the in page 20, that is typed page also 21. In 2018-19, further in page 18 and 19, again given the representation to the 3 and 4. And
You filed application in form number 57.
Yes, your lordship.
When?
2018-19. There is the endorsement given by the Tahsildar. I have given typed copy also in page 21. Subsequently, they are not considered, and again I have given the representation on 23/2/2022 to the Tahsildar and Assistant Commissioner. My father was in cultivation, poor agriculture family, more than 40 years. Then he passed away. The petitioner is in the possession of the property, is doing cultivation. Produced the photographs also in page 16 and 17, your lordship. I am a permanent resident of this village. I have produced the Aadhaar card in page 15.
ಅಲ್ಲ ಇಲ್ಲಿ annexure D ಅಲ್ಲಿ therefore we will direct you to find out If the application is found, then let the Tahsildar make a report and place it before the committee. Otherwise, if they find that no such application is pending, you give them an endorsement. Worker. The prayer in the writ petition is to issue a writ of mandamus, directing the respondent authorities to consider the application filed by the petitioner in form number 57, seeking regularization of unauthorized occupation of 3 acres of land in survey number 10 of Shekalahalli village, Sasalu Hobli, Dodlapur Taluk. So, learned counsel for the petitioner submits that at annexure D, the petitioner has produced a copy of the acknowledgement given by the Taluka Shirestadar for having received the application filed by the petitioner in form number 57. Stop. Then a council submits that till date, the application has not been considered by the committee. Stop. Next para. Having regard to the prayer made in the writ petition and the contentions of the petitioner, this court is of the considered opinion that the respondent Tahsildar, Dodlapura Taluk, is required to consider the application said to have been filed by the petitioner, prepare a report and place it before the committee. Stop. Next para. On the contrary, if the Tahsildar finds that no such application is filed by the petitioner, then the petitioner shall be called to the office of the Tahsildar and the original register of the applications shall be perused in the presence of the petitioner and to the satisfaction of the petitioner. Stop. If no such application is found, an endorsement may be issued by the Tahsildar. Full stop. Next para. Consequently, the writ petition stands disposed of with a direction to the fourth respondent, Tahsildar Dodlapur Taluk, to place the application of the petitioner along with a report before the committee for regularization of unauthorized occupation within a period of 2 months from the date of receipt of a copy of this order. The committee shall thereafter consider the application and pass necessary orders within a period of 2 months from the date when the application is placed by the Tahsildar before the committee. Full stop. Next para. On the other hand, as stated herein above, if the Tahsildar is satisfied on verification of the register in the presence of the petitioner that no such application is received, then an endorsement may be issued to the petitioner.
Much of
But my father purchased 10 acres of land under the register of KBT day in 1962. On the basis of the same influence, 1968, 69 to 2000, 2001. But the dictation was accepted and on the basis of the dictation, articles were issued. But at the time of uploading the digital article, I gave computerization. My name came to be discontinued. So thereafter, I gave representation to the Tahsildar. But based on that, annexation code in page 88. But Tahsildar sent the report to the Assistant Commissioner. Page 88. ಲೇಖನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಗುಜರಾತಿ ಹೋಗಿ 600 ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 14ರಲ್ಲಿ 10 ಎಕರೆ ಜಮೀನನ್ನು ಕೈಬರ ಪಾಣಿಗಳಂತೆ ಗಣಿತ ಪಾಣಿ ತಿದ್ದುಪಡಿ ವಿಚಾರದಲ್ಲಿ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಈ ಕಚೇರಿಯಿಂದ ದಿನಾಂಕ 27/4/2010 ತಮಗೆ ಸಲ್ಲಿಸಲಾಗಿದೆ. ಈ ಬಗ್ಗೆ ಪ್ರಸ್ತುತ ಜಮೀನಿನ ಮೂಲ ಮಂಜೂರಾತಿ ಕಡಿತ ಪತ್ತೆ ಹಚ್ಚಿ ಮಂಜೂರಾತಿ ಜಮೀನಿಗೆ ಸರ್ಕಾರಕ್ಕೆ ಸಹಾಯ ಮಾಡಿದ ಬಗ್ಗೆ ದೃಢೀಕೃತ ದಾಖಲೆ ಪಡೆದು ದಾಖಲೆಗಳ ನೈಜತೆ ದೃಢೀಕರಿಸಿ ಗಣಿತದ ಭಾಗದಲ್ಲಿ ಯಾವ ಕಾರಣಕ್ಕಾಗಿ ದಾಖಲೆಗೆ ಹೊಂದಿರುವುದೆಂಬ ಮಾಹಿತಿಯನ್ನು ಹಾಗೂ ಸರ್ಕಾರಿ ಜಮೀನುಗಳ ಅಳತೆ ಕಾಲದಲ್ಲಿ ಹೇಗೆ ಪರಿಗಣಿಸಲಾಗಿದೆ ಎಂಬುದರ ಬಗ್ಗೆ ಮಾಹಿತಿಯನ್ನು ಮೂಲ ಮಂಜೂರಾತಿ ಕಡಿತದೊಂದಿಗೆ ಸಲ್ಲಿಸುವಂತೆ ಉಲ್ಲೇಖದ ತಮ್ಮ ಪತ್ರದಲ್ಲಿ ಸೂಚಿಸಲಾಗಿದೆ. ಮೂಲ ಮಂಜೂರಾತಿ ಕಡತದಲ್ಲಿರುವ ಸಾಗುವಳಿ ಚೀಟಿ ಮತ್ತು ಮಂಜೂರಾತಿ ಜಮೀನಿಗೆ ಸರ್ಕಾರಕ್ಕೆ ಇತಿ ಹಣ ಸಂದಾಯ ಮಾಡಿದ ಬಗ್ಗೆ ಟ್ರೆಜರಿಯಿಂದ ಚಲನೆ ಪಡೆದು ದೃಢೀಕರಿಸಿ ಇದರೊಂದಿಗೆ HM ಪಟ್ಟಾಭಿರಾಮಿಯವರಿಗೆ 1952-53ರಲ್ಲಿ ದತ್ತಾಂಶ ಮೂಲಕ ಮಂಜೂರಾತಿಯಾಗಿದೆ. ನಂತರ ಕೂಟ ಜಮೀನು ಶ್ರೀ ಕೃಷ್ಣಪ್ಪ ರಂಗಪ್ಪ ಇವರಿಗೆ 66-67ರಲ್ಲಿ ಕ್ರಯ ಮಾಡಿರುವುದು ಕಂಡು ಬಂದಿದೆ. ಹಾಗೂ ಕ್ರಯ ಪತ್ರದಂತೆ MR ನಂಬರ್ 2/6667ರಂತೆ ಖಾತೆಯಾಗಿ 1958-59ರಿಂದ 2001-2002ರವರೆಗೆ ಕೈಬರಹದ ಪಣಿಯಲ್ಲಿ ನಮೂದಿರುತ್ತದೆ. 2001-2ರ ಪಣಿಯಂತೆ ಕೃಷ್ಣಪ್ಪನವರ ಮಕ್ಕಳ ಹೆಸರಿಗೆ ಖಾತೆ ಇರುತ್ತದೆ. ಈ ಹಿಂದೆ 2001ರಲ್ಲಿ ಕೈಬರಹದ ಪಣಿಯಂತೆ ಗಣಕ ಪಣಿಗೆ ಡಾಟಾ ಎಂಟ್ರಿ ಮಾಡುವಂತೆ ಕಂಡುಬರುತ್ತದೆ. ಸರ್ಕಾರಿ ಜಮೀನುಗಳ ಅಳತೆ ಸಂದರ್ಭದಲ್ಲಿ ಈ ಜಮೀನನ್ನು ಅರ್ಜಿದಾರ ಒತ್ತುವರಿ ಮಾಡಿರುವುದಾಗಿ ಸ್ಕೆಚ್ನಲ್ಲಿ ತೋರಿಸಿದಂತೆ ಒತ್ತುವರಿ ಪಟ್ಟಿಯಲ್ಲಿ ಇರುತ್ತದೆ. ಸರ್ಕಾರಿ ಜಮೀನುಗಳ ನಿಗಮದ ಜಾರಿದಾರರ ಪಟ್ಟಿಯಲ್ಲಿ ಸೇರ್ಪಡೆಯಾಗಿರುವುದು ತೋರಿಸಿಬರುತ್ತದೆ. ಆದ್ದರಿಂದ ಮೂಲ ಮಂಜೂರಾತಿ ಕಳಿಸಿದಲ್ಲಿನ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಮುಂದಿನ ಕ್ರಮದ ಬಗ್ಗೆ ತಮಗೆ ಸಲ್ಲಿಸಿದೆ. ತಮ್ಮ ಸೂಚನೆಯಂತೆ ಇದರೊಂದಿಗೆ ಮೂಲ ಮಂಜೂರಾತಿ ಕಡತವನ್ನು ಸಹ ಲಗತ್ತಿಸಿ ಸಲ್ಲಿಸಿದೆ. Based on this plot, this was passed in order directly on 15/6/2022.
In this order.
Of 15/6. The additional government advocate to secure instructions regarding the communication dated 9/6/2011. All letter ಬಗ್ಗೆ addressed by the Tahsildar to the Assistant Commissioner, in which the Tahsildar confirms the fact that there was a grant in favor of the petitioner tender, and thereafter the registration was continued in the name of the father of the petitioner, right from the year 68-69-2001-2, and during the process of the computerization of the RTC, the name of the petitioner has been omitted. To secure the communication. Records are 68-2002, and the original records were also sent to the Assistant Commissioner. Now the
ಎಲ್ಲ ಅದಾದ್ಮೇಲೆ ಏನಾಯ್ತು?
I gave a representation to the Tahsildar and all, but the Tahsildar issued an endorsement. Annexure came in page 81. ಅವರೇ annexure order ಕಳಿಸ್ತಾರೆ. Everything will be in order. Then when I made a representation to continue my activity on the basis of the changes and previous entry, the Tahsildar issued the connection order. Bangalore Pura Taluk ಇದರಲ್ಲಿ ಹೋಗಿ ಚಿಕ್ಕಂದ್ರ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 14 ಜಮೀನಿನ ಬಾಣಿ ನಮೂದುಗಳ ತಿದ್ದುಪಡಿ ಕೋರಿ ಈ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಮನವಿ ಸಲ್ಲಿಸುವಂತೆ ಬಾಣಿ ತಿದ್ದುಪಡಿ ಮಾಡುವ ವಿಚಾರದಲ್ಲಿ ಮಾನ್ಯ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸಲ್ಲಿಸಲಾಗಿದೆ. ಅರ್ಲಿಯರ್ ಆ ಸರ್ವದಲ್ಲಿ ರೆಫರ್ ಮಾಡಿದ ಉಲ್ಲೇಖದಲ್ಲಿ that assistant commissioner order ಮುಂದುವರೆದು ಉಲ್ಲೇಖದ ಮಾನ್ಯ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳ ಪತ್ರದಲ್ಲಿ ಮಾನ್ಯ ಎಟಿ ರಾಮಸ್ವಾಮಿ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ಸಮಿತಿಯ ಸರ್ಕಾರಿ ಜಮೀನುಗಳ ಅಳತೆ ಕಾಲದಲ್ಲಿ ಕಂಡು ಬಂದ ಒತ್ತುವರಿ ಪಟ್ಟಿಯಲ್ಲಿರುವುದರಿಂದ ಹಾಗೂ ತಮಗೆ ಸದರಿ ಜಮೀನು ಮಂಜೂರಾದ ಬಗ್ಗೆ ಯಾವುದೇ ಗಡಿಗತ ದಾಖಲೆಯನ್ನು ಹಾಜರುಪಡಿಸಿ ಆದ್ದರಿಂದ ತಮ್ಮ ಕೋರಿಕೆಯನ್ನು ಪರಿಗಣಿಸಲು ರಾಜಕೀಯವಾಗಿ ತಮ್ಮ ಮನೆಯಲ್ಲಿ ಒಂದು ವಿಲೆ ಇಟ್ಟು ಕಚೇರಿ ಕ್ರಮಾಂಕವನ್ನು ಮುಕ್ತಾಯಗೊಳಿಸಿದೆ. The very Tahsildar has sent the entire grant by with a certified copy of the payment made to the treasury and all other records. And the very same Tahsildar issued.
Yeah, why did you not persuade this order 15/6? ಅದಾದ್ಮೇಲೆ ಏನಾಯ್ತು? Released on 22/6. ಏನಾಯ್ತು? When it comes in for the petitioner has drawn the attention of this court for interim order dated 15/6 to the interim order dated 15/6/2022 passed by this court. Stop. The learned AGA was directed to secure instructions regarding the communication dated 9/3/2011 made by the Tahsildar to the Assistant Commissioner. Practically Annexure O dated dated is it? Close bracket. Stop. Next para. Release this matter on 11th of October 2022. Stop. Learned HCGP is once again directed to ensure that there is compliance of the order dated 15/6/2022. ಯಪ್ಪ ಅದರಲ್ಲಿ ಆ ಕಮ್ಯುನಿಕೇಶನ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಎಲ್ಲ ವೆರಿಫೈ ಮಾಡಿದೀನಿ ಒರಿಜಿನಲ್ ರೆಕಾರ್ಡ್ಸ್ ಎಲ್ಲ ಒರಿಜಿನಲ್ ಗ್ರಾಂಟ್ ರಿಜಿಸ್ಟರ್ ಅಲ್ಲಿ ಗ್ರಾಂಟ್ ಆಗಿರೋದು ಕಾಣಿಸುತ್ತೆ ಅದ್ರ ಕಾಪಿ ಅನೆಕ್ಸ್ ಮಾಡಿದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ. therefore now they cannot say ಇಲ್ಲ contrary opinions. So therefore you have to secure the original records. If the Tahsildar says illa grant original grant register alli entry illa antandre you summon the grant records, verify yourself.
The serial number 56, my lord.
57 nimdu Subhash avare.
Yes, sir, my lord. It may kindly be taken up after vacation, my lord.
The request of learned counsel for petitioner lists this matter after Dasra vacation.
My soul.
Is this matter after Dasra vacation? Secure instructions from the respond authorities as to whether the respond authorities are seeking to take action against the petitioner in spite of there being a decree of permanent injunction in favor of the petitioner in area number so and so dated 75 At the same time, learned counsel for the petitioner is also required to take instructions from the petitioner as to whether his claim is for grant of alternative lands on account of submergence of his lands, or is it a claim for consideration of the application said to have been filed by the petitioner in the year 1999 seeking regularization. Yeno. If you are entitled for an alternative land, there was no need for you to make an application under section 94 capital A. Therefore, I have asked you to take instructions. What is it that the petitioner says?
Until after they are cultivating the southern land. Measure 30, normal land, 2 acres, 20 acres. This one may feel today. By annexation, there is an injunction order.
Yeah, pa. Any instruction? You don't have. Berkeley. Although directions were issued to the learned AGA to secure instructions from the respondent authorities. Learned AGA submits that no instructions are made available. Stop. Next para. The respondent authorities are hereby directed not to dispossess the petitioner until further orders. Yes.
I appear for the petition season number 44. I was held up in court on 19 minutes was taken up. The IO date 14/9/2022 is to be extended. It is adjourned post vacation. Much obliged.
Yeah,